And I also gather that Mrs. Seeley Brown would take us and direct us through these list of amendments. Some of them might cause for some consequential policy direction changes. And so it's important for us to, as a committee, to review them, get an understanding, and determine the way forward in terms of those required policy directives. Senator Campbell Rodriguez, I'm seeing your hand.
Yes, thank you. I just had a quick question. So we're going to look at the list of amendments versus the full final draft report. I asked because other than just the amendments themselves, I think the flow of the document, now that the amendments are in, it may be useful if we go through the report and, you know, just so we can see the flow and we can make sure that everything makes sense versus, again, looking at it in pieces.
So we want to see how it really, the amendments really fit into what is going to be proposed as the amended legislation, right? And normally, when, if you recall, in the sittings of the Senate, and I'm seeing that the representatives here are mostly from the Senate today. So you know that when we are going through in the committee stages, we usually look at the amendments and indicate where those amendments would form part of the legislation. So I gather that when Mrs. Seeley Brown is going to take us through, she will guide us through the proceedings. Right, Mrs. Seeley Brown?
Yes, Chair. I intend to take us through the list of amendments. What I did, Ms. Grant will soon share her screen. I did a mock-up in the bill itself, and I've put in what you have in your list of amendments. In that bill, so you will see exactly where the amendments will be inserted, as I've indicated. The changes that have been made on the list, you will see them in the actual bill when she puts it up. It's not a document that can be shared for the parliamentary record, but it's just to guide members to see exactly where the amendments have been inserted in the legislation.
And so that will take care of Senator Campbell Rodriguez's concern.
Yes, Chair.
Okay.
Thank you.
All right. So you can proceed, Mrs. Seeley Brown.
Yes, Chair. I'm just waiting on Ms. Grant. Ms. Grant,
Ms. Grant, share.
Share the screen so I can take you through the list and the provisions. And there's some issues, Chair, that are still square bracketed, because you'll appreciate while we were making the amendments, because we've changed some aspects of the scheme of the bill, there were some consequential amendments that were also made. I've tried to improvise and put in some provisions that I think may be applicable in square brackets. The committee will now have to make a decision as to whether they accept the proposals that I'm putting forward with regard to those provisions.
And so when you get to those, you will highlight those for our attention.
Yes, Chair.
All right, thank you.
Georgette, I'm not seeing, so I don't know, can you just minimize it a little bit, please? Right, so what you're seeing on the screen, Chair, is the bill with the track changes of the amendments inserted, so that you can follow, members can follow from their list and see where we have inserted these amendments in the bill. We're not able to read it clearly.
We're not able to see it clearly.
All right, give me a moment.
Sure, take your time.
I wanted to show the markup, but it seems that when I share it, okay, let me do it in this mode and see. Okay, if I make it bigger.
No, you need to make it a little. It's not, no, it doesn't need to be big. It needs to be a little, just that we can't read the print properly, Georgette. I don't think you need to make it bigger. Just make the, you can go back a little.
And it's still, you still can't read the print properly.
Yeah, can you minimize it a little bit, minimize it a little bit more, please? Because remember, the members have the list in it. It's just to show them
where it fits.
Yes, that's fine. No, you just had it. You had it just a while ago, Georgette. Back a little. Yes, yes.
This reminds me of the days when you have an antenna on the roof.
Yes, that's fine. That's fine. Thank you so much, Georgette.
Welcome.
Yes, colleagues and members. Before you, you have the list of amendments as they will be tabled in the House of Representatives with the report. And one of the first amendments that was—
Sorry, it's gone back. It's gone back to the
Yes,
fuzziness.
going back.
Can we just not touch it again? Don't touch it, please.
I didn't touch it. Don't know what's happening. I'm going to stop sharing and reshare. I didn't touch it at all.
Okay.
Hopefully this will, okay. This will be better now. Hopefully. Is it better now?
No, it's
back to fuzzy. All right. How about this?
Still fuzzy.
Okay, come on, computer. This is okay?
Still fuzzy. That's even worse, Georgette.
Worse. Okay.
Yeah. Still fuzzy. Still fuzzy. Minimize a little bit more. Yeah, I think you need to minimize it a little. Go back a little. No. Yes, yes, yes. Don't touch it. Yes.
Okay, not touching it.
Right ahead. Yes, yes, Chair. So one of the first proposal that was made before the committee was for us to amend the title of the bill and to have the different days be appointed by the minister for different provisions of the bill to come into effect. And that is what we did with clause 1. If you look at the list of amendments, we deleted clause 1 and we substituted therefore the following. Do I need to read it into the record, Ms. McCarthy?
Yes, yes, Mrs.
Okay, so the amendment will now read, Chair. Short title and commencement. This act may be cited as the Sexual Harassment, Protection and Prevention Act 2021 and shall come into operation on a date to be appointed by the minister by notice published in the Gazette, and different days may be appointed by the minister under this section in respect of different provisions of this act.
And that's what we had agreed to.
Yes, Chair.
Right.
So you would see it there. The second amendment now, Chair, will be to clause 2, where you had asked for certain provisions, certain definitions to be put into the bill. And some definitions have been put in as a result of some consequential or other amendments that were made when the scheme of the bill changed, Chair. So for instance, remember we spoke about applying sexual harassment, the sexual harassment policy to deal with clients, persons who come into your business to do services. And so for that reason, Chair, we have put in a definition of client, and it reads, client means a person who conducts business with an employer. And then I think it was Senator Sophia Fraser-Binns and Minister Kamina Johnson-Smith who had an issue as to whether or not we should define contractor in relation to when we come to the persons who shall not commit acts of sexual harassment. And I've put in this definition, but with a caution. When I read it, you would see that I have a footnote to it, which says that we, in our view, because we have defined client very broadly, we don't think that we need to define contractor as is defined here, as it's proposed here. So that is something that the committee will have to look at and advise us on. So contractor means a person who is hired by an employer to perform specific work or provide a specific service for compensation and reward. And my footnote reads that the definition is meant to cover a person who is hired by an employer to do work or perform a service. Also, in light of the definition of client as inserted and paragraphs C and D of the current definition of worker, I would like the committee to consider whether the insertion of this definition is necessary. Because I'm thinking, Chair, client is broadly defined, and I think in the way it is proposed to be used in the bill, I think it's in the new clause 8, the new clause 9 as renumbered. I don't think we may need to define contractor, because I am of the view that the definition of client and the way worker is defined takes care of that. So that is something that we would like for we would wish for the committee to consider, Chair. Before you do that though, Chair, document was inserted as a continental amendment, because I think we have used it in the provision that deals with the establishment of the register as was proposed, and that is just a definition that is in the Evidence Amendments Act, just to make it a standard definition. And sexual harassment claim as distinct from a complaint was defined because the committee had instructed us that you wanted us to initiate a procedure for having a worker making a claim to an employer or a person who works at an institution or is or an inmate, or that long list is part of an institution, to make that complaint to that institution, to make that first sexual harassment claim. When you use complaint, complaint is specifically defined in the Act to mean somebody who makes a complaint to the tribunal. So when we get to that section, it will become clearer why we had to use sexual harassment claim in that regard. But for now, Chair, we would just like the committee to consider whether the way we have defined the manner in which client is defined, if the committee is still of the view that we still need a definition of contractor as is proposed in the list of amendments, Chair.
So let us first deal with the term contractor, and going back to clause.
It would be when we were dealing, Chair, with clause
2. The definition of worker.
Yes.
So the definition of worker in
Mr. Chair.
Yes. Senator Campbell Rodriguez.
Yes, I was just saying that under 2C, under the definition of worker, part C.
Yes.
I think that takes care of contractor.
Yes.
Right.
Yes.
Right.
Yes.
Exactly.
I don't think we need a definition there.
So we don't need a definition for contractor. And so we can use the definition for client.
Yes.
That means a person who conducts business with an employer.
Yeah, we
Yes.
have that view, but you have to remember, Chair and Senator Campbell Rodriguez, when we didn't have the benefit of the definition of client when that proposal was made. So now that we have included client, I don't think we need the definition of contractor.
Right.
And I agree with you.
Yes.
Agreed.
So we will take that out, right?
We'll
Chair?
take it out.
Yes.
All right.
Excuse me, Chair. So that means, based on what we're saying now, I would have to amend the report, that
Yes.
report, and add client instead.
Yes.
There you go.
Yes. As I said, document this as a matter of course, and it just takes the definition of the Evidence Amendment Act. And when we get to the new clause 5 and 6, you would see the reason why we had to make a distinction between a complaint that is made to the tribunal and a sexual harassment claim, which is made by a worker to an employer or by a student, inmate, etc., to a person who is in charge of an institution. Okay.
And that means that is the trigger in the internal situation.
Yes, sir.
Okay.
Correct. Yes. All right. And then we move on now to item 4 on the list of amendments, where you had the committee instructed the technical team.
Sorry, Mr. Steely Brown.
Yes, Georgette.
I just have this thing here about, just to show you, if I hope this screen is still clear.
It
Just
is.
show where we had agreed, it was agreed for the reasonable and unreasonable to be taken out, just so that they could see it.
I'm getting to it now, yes. In the definition of sexual harassment, members, you had asked for us to remove the terms reasonably and unreasonably wherever they appear in the in the definition of sexual harassment, and we have done that. And you would see
Okay.
it on the screen.
All right.
Okay. I did.
Sorry,
check.
excuse me.
Yes, Senator.
Sorry.
Yes. Yes.
Is that removal of the term, the terms reasonable, the words reasonably and unreasonably? Is
Yes.
it throughout the document or just in a particular place?
No, I can't remember us being instructed to remove it throughout the document.
No, what sections was it? Because I remember it also being discussed, where that in the definition, but there was one other section in the document.
I'm not sure. Can we just, so I'll flag that because I can't remember. I know we have used it before, but I don't think we needed to delete it in that instance, but I'll just flag that and make a note of it, Senator Rodriguez Campbell, so that when
And
we
so
get to that
when we
provision,
get to it,
we can look at it.
identify. Yeah.
Okay.
All right.
Right, and then, okay, so I did a bit of a tidying up, Chair, in the definition of worker. If you recall, there was I think there was a group, I can't remember the name of the organization, who kept asking us to define a person conducting a business or undertaking. And our response was that it wasn't used in the bill. When I looked at the definition of worker, that definition was just coming from another place where we had actually used the terms person conducting a business or undertaking rather than employer, still remain in the definition of worker. And I am advising that for ease of reference and clarity, we delete those words in the definition of worker, person conducting a business or undertaking, and substitute it with employer. So it would read as is here in the thing, a worker means a person who carries out work in any capacity for an employer, including work as, and the paragraph continues. So that was just a mop-up, a tidying up there of the draft.
Because one of the things we have always expressed the concern around is that the definition of worker should be the same definition in all legislations.
Yes.
So how does this now, this defined definition, treats with that particular situation? And I recall in another legislation that is under review, we would have used
that's the occupational health and safety.
Occupational
but
safety.
remember, Chair, because you're part of that committee, we had defined in that that definition, that other law where we hadn't used employer, a person conducting a business.
Okay, yeah, all right.
But
it was the employer.
We haven't done that, and we have defined employer here, and we must sync it with the definition of worker. So that's all that was done. We took out the person conducting a business or undertaking, and we've put in employer there.
Okay. All right.
Chair, I see Miss Simon has her hand up.
Yes, Miss Simon.
Sorry. Yes. Yes, Chair. It was just with regards to the member Campbell Rodriguez, the concern about the reasonable.
Mm-hmm.
I found it in the report on page 13 of the report. It is said that your committee notes a proposal that all references to the term reasonable or reasonableness in the sexual harassment will be removed due to its subjective nature. Your committee does not accept the proposal to delete the terms reasonable or reasonableness and agrees such references throughout the Act should remain as is, except in the specific instances as outlined in this report.
Okay.
All right. And so the definition of sexual harassment would be one of those specific instances.
Yes, Chair. So, but what I said, we can still flag the others, just to make sure that.
Yeah,
definitely. Okay, and then Chair, in that same clause 2, we have inserted, Georgette, can you move the screen, please? We have inserted 2 new subclauses in clause 2, subclause 3. subclauses 4 and 5, right? And that was to take care of the instructions that were given to us that the provisions of this act shall not apply to a person who is under the age of 16 years. So that is in new subclause 4. Right, and then remember we had also, the committee had also agreed that you wanted a fit and proper test to deal with members of the tribunal and their eligibility for appointment. And the technical team did that and inserted a new subclause 5, which I'm going to read into the record. For the purposes of section 13.2, that is a section that deals with the appointment of the members of the tribunal. A person is a fit and proper person if A, the person has not been convicted of an offense involving fraud, dishonesty, or moral turpitude, or of an offense listed in the second schedule of Proceeds of Crime Act, or an offense that is similar to any such offense in any other jurisdiction, is not a bankrupt within the meaning of the Insolvency Act, and is in compliance with any tax or other statutory requirements imposed on the person. B, the employment record of the person or any other information does not give the minister reasonable cause to believe that the person carried out any act involving dishonesty or impropriety that will interfere with the ability of the person to fulfill his or her functions. And C, the person is, in the opinion of the minister, a person of sound probity and is able to exercise competence, diligence, and sound judgment in the fulfilling of their functions, a person who possesses the knowledge, skills, and experience which are necessary for the intended functions to be carried out by that person. And 3, a person whose appointment will not raise an issue of conflict of interest or undue influence. So once the committee accepts that, we can remove the square brackets from that provision, Chair.
Is this listing aligned to any other legislation that has
Yes.
a tribunal? Yes,
Chair, to the, I think guidance was sought from the Anti-Doping Act, the
right.
banking, the amendment that was done to the Bank of Jamaica Act.
I remember,
yeah,
I remember this coming from the DOJ.
And I just tweaked them to suit the circumstances with respect to the tribunal under this act, Chair.
And I mean, and specifically for B, the employment record.
Yes, Chair.
All right, committee?
I have a question.
Yes.
And I hope Senator Longworth is on to correct me if my question is inappropriate. But under C, where it says the person is, in the opinion of the minister, a person of sound probity and is able to exercise competence, diligence, and sound judgment. Are we looking at mental incapacity there? I'm trying to choose my words correctly.
When we use it, it's not necessarily, we've not used it to deal with mental capacity. It's just that you're competent in relation to whatever field you may have been appointed to the tribunal to represent, that sort of thing. You're diligent in the way you carry out your duties and judgment. We've never used it, but when we link in things to the mental, to anything to do with mental health, we always use the provisions pursuant to the provisions of the Mental Health Act, which we don't really do things like these. Go ahead, Senator.
The reason I raise it is because it is, I don't know what it is in Jamaica, in our jurisdiction, but usually you want to ensure that whoever you appoint to a tribunal is not unsound. I don't know what the proper terms are, so help me here. How do we, because I was wondering if it could fall under C1, but if you're saying no.
Well, if you're mentally, I want to choose my words right too. If you are
just to relate that I am here and I am listening.
Yeah, if you are,
Would like your feedback.
I'm
waiting to hear what is being discussed.
You're mentally unsound.
The thing is, Senator Rodriguez Campbell, when we are things to mental health, Senator Rodriguez, sorry, we usually use the Mental Health Act. In this instance, we're not doing that. We're speaking of their competence to perform your functions, nothing to do with, we've never used it in any way to deal with mental health. Because we're thinking that whoever is appointing would obviously, if in all fairness, if you're a person who is competent and diligent, it means that your mental health will also be intact, in my view. I mean, I'm not a doctor, but we've never used that. If we're going to tie anything to mental health, we tie it to the provisions of the Mental Health Act.
Which in and of itself is under review, just to add that.
Yes,
Senator Campbell Rodriguez.
So
what you find is generally there is, in my opinion, a little bit of inefficiency with respect to the legislative process and the consideration of health generally, but especially mental health capacity. So I think that once the reference is made to the Mental Health Act, which is being reviewed now and basically being redrafted, that we consider that all legislation that refers to it takes whatever needs to be amended there into consideration, right? Yeah. So I think that I'm hoping that the process is such that, especially with the references being made to the Mental Health Act, that when that act is being reviewed, that we have those references listed as being needed to ensure that there is proper coverage. But in this context, I think it is the competence of the individual to serve in this function, and for them to even be considered for an appointment, that competence would have to be demonstrated.
Yes, that is correct.
So then, can we then say that C1 handles the issue of mental competence, not in terms of cerebral competence, but in terms of mental health?
I think it probably would need to say that it's the capacity to function in the role required.
Yes.
Right, but what here deals with that?
Necessarily does not have to be limited to mental capacity.
No, man, I agree with you 100%. But I'm speaking specifically now to the mental health, because the other areas of competence, I think, are handled quite clearly here. But I am saying I'm not seeing enough evidence, unless I'm misinterpreting.
So a person of sound probity
is somebody who has
who
should have their faculties together.
Right, that's why I asked the question and I was told no, because I thought it could be covered under C1, CI. But from the response from Mrs. Seeley Brown, it doesn't seem as though that was the intention of CI.
Well, I'm sorry if I made it sound as if that wasn't the intention. It's just that I said to you, when we are dealing specifically with mental health issues, we would normally use that act. But if we have, I went on further to say, if you're a person who exercises competence and diligence and sound judgment, it is taken that your mental health is intact. If you look at, when we look at, for instance, Senator Rodriguez Campbell, when you look at the other provision further on, when it speaks of a person not being able to hold a position anymore in the tribunal, it speaks of if the person, I think, is of unsound mind or something. So you deal with that where you say you can be disqualified from holding a position if that is the case. So I think it deals with it in that regard. I think
okay.
I'm comfortable with it as is. As I said, I just hope that there would be specific reference when we review the Mental Health Act, that these references are taken into consideration.
I see Senator Scott Motley's hand is up, Chair.
Okay, Senator Scott Motley, welcome.
I've been here a long time, Chair, since about 5 minutes past 10. But I wanted to make an observation that firstly, we have to have some level of confidence in our ministers, regardless of whichever side they represent. And we have to have that confidence that they will select persons very carefully. Senator Longmore is an expert in this area, but I think the mental health of a person cannot be determined by outward appearances, unless it is highly exaggerated, very clear, and it is exhibited in certain circumstances. a minister would not have access to that kind of information. And it is for this reason, I think, where the Act actually specifies the circumstances in which a person can be removed, because it would be then pellucid that this person would be lacking in the capacity to continue to function in terms of the appointment which has been made. But I think I understand exactly what Senator Natalie Rodriguez Campbell, I get confused, like, because people are confusing me, Senator, you know that I know
Campbell
exactly.
Rodriguez.
I know you're exactly what your name is, since I'm extremely familiar with your husband.
Just remember the Spanish one is the last one.
No, I know her husband very well. He's a Clarendonian, you know, Senator, so what you expect.
And you say, I'm outside of the border of that parish.
But I understand her concerns, but I do believe that the way that it is structured now is satisfactory. And I think her concerns are met by the clause that says how they can be removed. Thank you, Chair.
Thank you very much for that. And I agree, Senator Scott Motley, because this is the particular clause that determines your eligibility, and also the clause that defines whether or not you continue to be suitable to serve. And so what is expressed here is a listing that can be exhibited. It can be picked up. It can be so physically seen. It's kind of difficult to determine the scope of the mental capacity or mental health. Okay. Save and except where Senator Longmore comes in to make that determination. So for the minister to determine eligibility and for the minister to determine whether or not you're suitable, what is contained here is expressively defined.
Yes, yes. And we cannot just go, just to add just a footnote there, that you cannot just say any mental impairment, because that still does not mean that you're incapable of logical and rational thought. So I'm very comfortable. And like I said, my main concern, and this goes across not just this piece of legislation, but it's the reference that it becomes that important that we recall this when we're reviewing the Mental Health Act generally.
I can be stressed and be viewed as mentally impaired. I just can't think.
We're all mentally affected.
All right, so we can agree on this clause then as put. So Mrs. Seeley Brown?
Yes, Chair.
You can move on.
Yes, Chair. The next amendment was to clause 4 of the bill, Chair, where we were asked to delete the chapeau, subject to subsection 4, and it should now read every employer, and you see we have made that change. And then the next change was made in subclause 3. I think you went too far up, Georgia. Right, where we are now, we wanted to link what must be in your policy statement. You wanted the ministry wanted to use this sexual harassment framework document as a template, and so yes, we amended subclause 3. We deleted subclause 3 and substituted the following: the chapeau to subclause 3. The policy statement required under this section shall be in accordance with the sexual harassment framework document set out in the first schedule and shall include the following. And so it continues as is in the bill, and then we had to include, so we deleted paragraph B because we are now including clients as part of the construct of that framework for persons who may be harassed or may be sexually harassed. We have 3, so we did, and it would read now, a statement to the effect that workers, clients, students, residents, wards, inmates, patients, or members, as the case may be, at or of the institution, are entitled to an environment that is free of sexual harassment. In paragraph C of that, and then these are the amendments, Chair, in paragraph C, D, and E, would then include client in all of the other provisions so that that document must, and then we deleted paragraph H, Chair, because you wanted it to be subject to section 27.5, that section that speaks to the fact that you don't have to always use the internal mechanisms to, if you think that you will not have a fair hearing. So we inserted subject to section 27.5, a statement to the effect that the complainant shall exhaust all internal mechanisms and procedures that are available to the complainant before making a complaint to the tribunal.
Right.
I just wanted to state, Chair, before we move on, it's not clear, Georgette, on the screen that the framework document is also incorporated. We see it at the back as Schedule 1 of the Act now. Then I think it was a concern that was raised by Senator Campbell Rodriguez with respect to the transitional period for having this framework document, this policy document ready. And as a result, the technical team inserted a new subclause 4 to read. Within 12 months from the date of commencement of this Act, every employer shall ensure that the policy statement required under this section is prepared and shall take such steps as are reasonably required to bring the policy to the attention of each worker, client, student, resident, ward, inmate, patient, or member as the case may require. Chair, I'm seeing something that I left out there. It should read, because it's not just the employer, it should be every employer and person who is in charge of an institution. So after employer, Chair, on page 3 of the list of amendments, it should read every employer and person in charge of an institution.
Every employer and?
After the word employer in the new subclause 4, it should read every employer and person in charge of an institution shall ensure that the policy statement under this section is prepared and take such steps as are policy to the attention and student, resident, ward, inmate, patient, or member as the case may require.
Let me ask a question. Let me ask a question here. So I can understand required to bring the policy to the attention of each worker. What is expected in terms of the client to bring it to the attention of the client? In this case. So you make your policy available to the workers you employ. The students are part of your institution, the residents, the wards, the inmate. Maybe the patient when the patient comes in. But how do you make it available to the client?
I guess you'll have to put it in a conspicuous place in your office.
At a conspicuous place.
I'm just saying, I mean, I'm not, we don't do what, yeah.
I'm recalling the OSHA.
Yes.
Again, where there was a long debate around where you place that statement. For those doing business to see it.
Chair, I see Senator Rodriguez and Ms. Simon hand is up.
Let's deal with Senator Rodriguez first.
Right. My question specifically had to do with the use of the word institution, where it says every employer or person in charge of an institution. Does that not leave out the person at the wholesale? So how do we include businesses? Because we don't usually use the word.
So no. The employer is the person at the wholesale.
No, but it says every employer or person in charge of an institution.
You remember
the way the sentence was read, maybe I misunderstood it, but the way the sentence was read, it implies you're only addressing institutions.
No, you remember, Rodriguez, person in charge of an institution is used as a construct when we're dealing with students and stuff, and employer is used in another construct. If you look at clause, so the employer is widely defined. And then if you look at how it is used in the bill, on page, throughout the bill, we speak of a person who is in charge has this duty. So I'm just using back those terms. Because I left it, I omitted it in my, when I was redrafting, and it should have been there. So that these were institutions, meaning your schools and your colleges and all of that, which I think we had defined, didn't we? Yes, and it's defined, yes, yes.
So there'll be a comma there somehow. I think it was just because I'm listening to it versus seeing it written.
So when you see the new list, you'll see it inserted correctly in that clause.
All right, thank you. But Mr. Chair, in terms of the point you were making, how do you bring the policy to their attention? It has to be in terms of signage being obviously displayed. I can't think of another way.
Yes, that's the only way I can think of. Ms. Simon?
Yes, Chair. It was just a minor note, and notice a dash in the word commencement. I just wanted to bring it to Mrs. Brown's attention.
Thank you. Thank you.
Okay, thanks.
It sometimes happens when you're doing this.
The transfer, yeah.
Yes. Okay, and then of course we did some renumbering of that clause, and I inserted this new subclause 5 check, because I'm thinking if you are putting the framework document into the schedule of the act, the minister should be able to amend that document without having to go back to Parliament every time. So you know, to actually do the amendment and have it done as an act, as an amendment act. So I'd put in this provision to say that the minister may by order amend the first schedule. So once members are comfortable with that, we can remove the square brackets and move on. So that won't have been something in the report, but I think it was necessary to put it in.
Yes, that's important.
You'll have to update the framework document from time to time.
Yeah, that's important. All right, you can move on now. Yes, please.
Okay. Then we were asked to basically reformulate clause 5 and to provide for the procedure for a worker or a person who is in charge of a person at an institution to make a sexual harassment claim within their organization, and we did just that. So you see where we have now delete clause 5 and substitute there for the following, and I would read it into the record. The marginal note reads, procedure for lodging sexual harassment claim and duty of employer. 5.1, where a worker alleges that he or she has been sexually harassed by another worker or a client, that worker may lodge a sexual harassment claim in writing with the employer. Subclause 2, where the sexual harassment claim is lodged with an employer under subsection 1, the employer shall A, in the case where the sexual harassment claim is made against a worker, notify the worker in writing or electronically within 2 days of receipt of the sexual harassment claim. B, in the case where the sexual harassment claim is made against a client, take such action as he or she considers appropriate in the circumstance. And C, commence an investigation of the sexual harassment claim within 14 days of the sexual harassment claim being lodged and complete the investigation without delay. Subclause 3, an employer who fails to take the required action under subsection 2 shall be liable for the failure to act, and a worker who is aggrieved by the failure of the employer so to act may make a complaint in respect thereof to the tribunal. So you see now why we inserted the definition of sexual harassment claim, Chair, and how it is used in clause 5, the proposed new clause 5 of the bill. So that is for the committee to consider, Chair, before I move on to the new clause 6.
Members, any comments?
Yes, sorry.
Yes.
Okay, 5.1, where it says, where a worker alleges that he or she has been sexually harassed by another worker or a client. Does it have to be in writing? Yes. The reason I ask about the writing is, what about those who can't read and write? I can't remind me if there's something in the act which allows for someone else to write on someone's behalf. I can't remember.
Well, two things, if I may, before anybody else comes in, Senator Rodriguez. Remember that you have also instructed us to, the committee instructed us to insert provisions for a register because of the time limit and other implications for bringing a claim further down the road. So you have asked us to put that register in place. So the complaint would definitely need to be in writing. Now, I think the concern that you had, it can be dealt with where we speak of further on, where we speak of where complaint can be made, because there's nothing that says that somebody can write the complaint on your behalf. And even if you can't write, you mark an X, and like what happens normally, and you say, this complaint is made by so-and-so who is unable to sign. That procedure that is used when somebody is unable to write. I don't see anything in the act hindering that sort of procedure to take place if that person cannot write. So, but it is necessary to put it in writing because we are now inserting that register, which we are mandating employers and persons in charge of institutions to keep in relation to sexual harassment complaints. But I don't know if Georgette wants to say anything further on this, as that's a policy matter, Chair.
No, I agree with it. What you have said there helps me out big time. I just want to be sure we're not locking out a set of people who can't read and write.
Yeah.
And since there's nothing in the act to prevent someone writing on behalf of someone else, I don't know why I had something in my memory where we were talking about.
No, we discussed it. We discussed it.
Yeah, we discussed it. I want to be sure that is in the act and we're not leaving out a set of people.
I think you're raising it, Senator, because it was discussed very, very widely. And there's nothing in the act that says that somebody can't write that complaint, but you must make your X or whatever. You must sign in whatever way to say that that complaint is made on your behalf. And the act does not prevent that.
I'm good then. We're all good. Thanks.
All right.
So we are happy with it, Chair. Is it that the committee is accepting the new clause 5, or we can move on to the new clause 6?
Yes.
Okay, so then we had to now, for the same reason, delete clause 6 and substitute it as follows, and I'm going to read it into the record. The marginal note reads, procedure for lodging sexual harassment claim and duty of person in charge of an institution. 6.1, where student, resident, inmate, ward, patient, or member, as the case may be, alleges that he or she has been sexually harassed by a person who is a member of staff or in a position of authority at an institution, or B, by one of his or her peers at an institution. Such student, resident, inmate, ward, patient, or member, as the case may be, may lodge a sexual harassment claim in writing with the person in charge of the institution. Subclause 2, where a sexual harassment claim is lodged with a person in charge of an institution under subsection 1, the person in charge of the institution shall A, as the case may require, notify the person who is a member of staff or in a position of authority, or the student, resident, inmate, ward, patient, or member who is the subject of the sexual harassment claim, either in writing or electronically, of the sexual harassment claim within 2 days of receipt thereof, and B, commence investigation of the sexual harassment claim within 14 days of the sexual harassment claim being lodged and complete the investigation without delay. Subclause 3, a person in charge of an institution who fails to take the required action under subsection 2 shall be liable for failure to act, and a student, resident, ward, inmate, patient, or member, as the case may be, who is aggrieved by the failure of the person in charge of the institution to take action, may make a complaint in respect thereof to the tribunal. Chair, remember we had introduced B, one of his or her peers, because I think the point was raised, I think it was by Senator Rodriguez, that you didn't just want to have it being persons who work at the institution who are being sexually harassed, but between peers, like an inmate to an inmate or a student to a student. And so we inserted paragraph B to deal with that.
Right.
Mr. Chair, I have a question.
Yes.
What happens if, okay, under 2 of that section, where a sexual harassment claim is lodged with a person in charge of an institution. What if the claim is against the person in charge of the institution?
I'm so glad you raised that, because that was one of the amendments, Senator Rodriguez, that I had to insert when I was redrafting that we didn't think of at committee stage. So it is now inserted. You notice I've inserted a new clause 7, and that is to deal with where the complaint, the same point you raised, Senator Rodriguez, where the complaint is against the employer himself or herself, or against the person who is in charge of that institution. So I've inserted that. After clause 6, insert the following new clauses. And this is my makeup, so the committee is going to have to tell me if you're happy with it.
So this is the one that ratchets it up right to the tribunal.
Yes, yes, yes. So it says making of complaint against employer and person in charge of an institution. And it reads, where an allegation of sexual harassment is made against an employer or a person who is in charge of an institution, the worker, client, or student, resident, ward, inmate, patient, or member, as the case may be, may make a complaint directly to the tribunal.
This is a very good observation.
So that is, yeah, so that is what I had inserted and would need your approval before we take it up.
With hands down, hands down. It's a very good observation, and I don't know how it missed us.
I'm surprised it missed us as well.
Yes.
So that
and you
is,
see,
thank you, Mrs.
because
Silver.
it was because we're always focusing on the employer to act.
yes.
And there was a time, you know, it just missed us. But I'm very glad that we're able to catch it.
Yes. So those
and also the manner in which, the prescribed manner in which it is going to be treated, Mrs. Seeley Brown, to escalate it directly to the tribunal.
Yes, Chair.
Because that really protects the alleged victim.
Yes, Chair. Yes, Chair. Sorry about that. And then, Chair, so we have inserted clause 6, and then the committee also instructed the technical team that you wanted us to insert provision to deal with a register. And so I have inserted also a new clause 8, which I would read into the record, maintaining of register. Subclause 1, an employer and a person in charge of an institution shall maintain or cause to be maintained a register containing the following information in respect of every sexual harassment claim lodged pursuant to section 5 or 6A, the name of the parties to the sexual harassment claim B, the particulars of the sexual harassment claim C, the date on which the sexual harassment claim was lodged D, any action taken by the employer or the person in charge of an institution in relation to the sexual harassment claim, and E, such are the particulars relating to the sexual harassment claim as may be prescribed. Subclause 2, an employer and a person in charge of an institution shall ensure that the information contained in the register is kept in a secure manner and that the confidentiality of the information is preserved, and shall A, take all necessary and appropriate measures to protect the information contained in the register from unauthorized access, unauthorized use, and unauthorized disclosure, and B, ensure that any person who has access to the register adheres to the measures referred to in paragraph A at all times. Subclause 3, no person shall disclose information which is recorded in the register in relation to a sexual harassment claim unless the disclosure is made with lawful authority. Subclause 4, pursuant to subsection 3, a disclosure is made with lawful authority only if and to the extent that A, the disclosure is made to a party to the sexual harassment claim upon their request. B, the disclosure is made to the tribunal where a complaint is made to the tribunal pursuant to section 27. C, the disclosure is made for the purposes of and is necessary for the discharge of any functions under this act or any other relevant enactment. D, the disclosure is made for the purposes of any proceedings, whether criminal or civil, and whether arising under or by virtue of this act or otherwise. Subclause 5, a person who knowingly or recklessly discloses in the register shall be kept for a period of, and that is square bracketed, Chair, because we have to consider that persons can bring claims up to 6 years after they have that they have been affected. And remember, we also have a clause which allows you to bring it out of time if you're out of time, if in exceptional circumstances. And so the committee will need to consider what will be an appropriate time frame for keeping this information, Chair, in that regard. And the technical team didn't have an answer to that because you weren't sure, you know.
The technical team, what?
We didn't have an answer as to how long, you know, I think that is something that needs to be determined by the committee. For how long should this information be kept by the employer and person in charge of an institution?
All right.
In light of the fact that, remember, your limitation period is 6 years, and it can, or it can be longer in exceptional circumstances, which you would see, which we have inserted further on in the draft, Chair.
Just remind me of that extended period. So the 6 years and the.
Remember, we had said that if you're out of time, but for whatever reason your circumstances are exceptional, the tribunal may grant leave for you to lodge your complaint. Remember?
Right. Yes.
Yes.
So in this case, Mrs. Seeley Brown, the records here would be evidentiary in nature.
That's what I'm thinking, Chair.
And so as a result of that, it ought to be in sync with the extended period.
But we see we have not identified that extended period. We have identified 6 years.
We have identified 6 years.
But we also said that you can bring that action outside of that 6 years. You can bring that complaint, you can make that complaint outside of that 6 years. So we are guided by what time frame you'll want us, the committee would want us to put here for that, for how long the register should be kept.
I'm just trying to recall in the discussions that we have had, if we had represented in any way, shape, or form a defined period.
Well, it would be.
We might not have agreed, but did we never discussed it.
Because remember we said you have up to 6 years, I think. Georgia can correct me if I'm wrong. You have up to 6 years. However, you're not, if there are some sort of extenuating circumstances as to why you didn't bring it between that 6 years, the tribunal could grant you leave. So that is the, you know, I mean, so that is the, we have to sort of cap it if you're going to have this information, if you want this information can be evidence in that case. So we have to come up with a time period that is reasonable outside of the 6 years, in my view, for this information. Because remember, this is information that is going to be kept by your employer, your previous employer, or that person who is in charge of that institution. So we seek guidance from the committee as to the time frame that should go in there, Chair. In that,
and we also have to take into consideration, on the other hand, the purging of records.
Yes, Chair.
So, committee members, any views?
Well, Chair, when we looked at other legislation,
I must say I like that color.
It doesn't look purple, does it?
No, it's not. It does not look purple.
Thank you. When we looked at other legislation, we had in fact gone an unusual route when we had made a time frame 6 years, because certainly in other jurisdictions, you had as low as 3 months and you had up to 12 months. I understand, of course, that once we have that provision that you can go outside of the 6 year period, we still have to create a period within which the information must be kept. And I'm thinking, Mrs. Seeley Brown, of that, I think it is in, I've been doing so many different joint select committees that sometimes I lose track, but I think it is in the NIDS draft that we have said that the information should be kept for like 8 years. I think so. If there's somebody in the technical team who knows differently, they can correct me. But I say all of that to say that 8 years, in my view, would be a reasonable time frame. because I can't think of you still have to have some kind of certainty about whatever you do, especially as a tribunal. And if we were to give an additional 2 years for storing the information, I think that would be quite adequate. If a victim waits an inordinate amount of time in order to pursue their rights, it will create a lot of problems also for those who have to defend themselves. And I think that the important aspect of the law must be the search to find a just solution in all of the circumstances. So I would, Chair, propose 2 years.
You mean two
Right.
additional years?
2 additional years.
Meaning going to 8.
Yeah. Did we ever define the circumstances to which this extension could be granted, or was it left to the determination of the tribunal?
It was, Chair, it was, we were instructed to use words, exceptional circumstances, and then the tribunal will determine when these circumstances are exceptional.
All right, fine.
That decision was guided by the view that certain circumstances might be very traumatic.
Yeah.
Right.
For the person who has suffered this, the harassment, for the victim, as we would say. But I still think, and I do feel that we must at the same time have some sort of cutoff point.
Yes, some sort of a cap. All right, so we can agree, members, on the 8 years.
Yes,
I'm in agreement.
All right, so Mrs. Seeley Brown?
Yes, Chair. I've inserted it.
Okay.
Right. And then we just did some renumbering of the clauses, Chair, as consequential amendments. So then we're now looking at the old clause 7, which is now clause 9 as renumbered in your list of amendments. And because we had to include client as somebody who can be harassed or sexually harassed, we had to redraft the subclauses to take care of that. So we renumbered the current subclauses 4, 5, and 6, the subclauses 8, 9, and 10. And then we inserted subclause into subclause, after subclause 3, the following new subclauses. So the new subclause 4, a client shall not sexually harass a worker. The new subclause 5, a worker shall not sexually harass a client. The new subclause 6, a worker shall not sexually harass a supervisor. And the new subclause 7, a worker shall not sexually harass an employer, which is what the committee instructed us to do, Chair.
Yes. So have we covered all of the potential harassers?
Yes, Chair. And then we just tidied up this subclause 10 as renumbered. I think we have to take out some words, claim or complaints. I just basically redrafted it to read: an employer shall not take any action which adversely affects the opportunities, terms, and working conditions of a worker who has lodged a sexual harassment claim or made a complaint under this act, or who has given testimony or otherwise participated in an investigation, procedure, or hearing initiated under this act. And then we did the same thing to clause 8, the old clause 8, which is renumbered now as clause 10. A student, resident, ward, inmate, patient, or a member of an institution shall not sexually harass one of his or her peers. And that will take care of the student to student.
So this is a peer-to-peer now?
Yes, Chair. So once you have accepted that, we can delete the square brackets and move on to part 4 of the bill and go through the amendments.
Members?
Aye. Yes.
Thank you.
Chairman.
Okay.
Proceed, Mrs. Seeley.
Right, Chair, you would recall that we had extensive discussions in relation to the role of designated officers, and the technical team was instructed to redraft that provision to adequately provide for the intention of the committee. So I will now read it into the record. The marginal note reads, designation of authorized officers. 12.1, the minister with responsibility for gender affairs may designate persons being field officers attached to the Bureau of Gender Affairs as authorized officers, and for the purposes of ensuring the proper observance and compliance with the provisions of sections 3 and 4. Subclause 2, a person designated as an authorized officer shall undergo the requisite training to assist them in carrying out their functions under this act. Subclause 3, an authorized officer shall be furnished with a certificate of designation. Subclause 4, an authorized officer in performing any functions or exercising any powers under this section shall, upon request, produce a certificate of designation. Subclause 5, for the purposes of carrying out their functions under subsection.
Sorry, why you have it written like that in terms of the
Request?
Yes.
Because I wasn't sure whether you wanted them to always produce it, or should they just produce some legislation when dealing with authorized officers, missing that you must do it on request, and some demand that you do it anytime you're performing your duties. So I wasn't sure which one the committee would have been minded to accept. So I inserted those words just for you to consider, whether you would want them to show it every time, or should they just show it when they are asked by the employer or whoever they are.
I can give you my personal reference in this, in that I believe it should be shown. Should be so this.
So it should.
That's my preference though. But I would welcome any comment from the members in this regard.
Mr. Chairman,
Yes.
I agree with you there. I support what you're saying. But also, I had a question. May I go ahead and ask it?
You want me to finish reading it first, Senator Rodriguez, and then we can look at it as...
Either way, but it's in the first section, 12.1.
Okay.
Where it says, the minister with responsibility for gender affairs may designate persons being field officers attached to the Bureau of Gender Affairs. So I would take out the attached to the Bureau of Gender Affairs, and let me say why. There are times different ministries use an entity such as the SDC to carry out certain functions. So there have been times when local government uses officers from SDC. There have been times when the Ministry of Sport uses officers from SDC, because it makes sense given the role of community development officers, if they still exist. So I'm just wondering if we're forcing ourselves into a possible amendment versus just leaving it as being field officers, so that if the ministry with responsibility for gender affairs ever has a reason to use another set of officers, it doesn't require an amendment to this.
Senator Rodriguez, I would have to let somebody from the ministry answer, because that was the policy that was in the old draft, and since you weren't instructed to take it out, I would want them to respond to it, Senator, as to why they would have carved it in this way when they were
I think a couple of weeks ago, I was trying to explain the reason we had put this in, or it was recommended that this be put in. And that was to have a mechanism where we would have persons who are so familiar with the issues who are able to take the complaints. At this particular point, the idea that Senator raised about, Rodriguez raised about having it broadened, I have no issue with that, because it would mean that you would have a larger pool of persons who can carry out this kind of investigation. And if it is that those areas, the SDC and other spaces, local government and so on, would be able to have such persons in place, then that's fine with us, because as you know, the gender machinery is not very large in terms of numbers and capacity. And so we are not averse to having that, as long as there is an understanding that all persons would be getting the similar training and there's communication. What we had proposed to the ministry is that there is provision made for these officers with specific duties that we were asked to do based on the ministry. So we had crafted a particular set of duties with a job description, and the ministry was supposed to assist us with the nomenclature and so on. So that's not an issue if it is that is going to be coordinated. So perhaps if you could identify that coordinating mechanism, that would probably help. But we are not averse to that recommendation.
So Ms. Coburn, so are you then saying we can just end that section as persons being field officers as authorized officers for the purpose? So we can leave out attached to the Bureau of Gender Affairs?
I'm not sure, because if you leave it out, how would you know which entities are you referring to?
Because my thing is you don't know now. So for example, in the 90s, early 2000s, the Ministry of Sports assigned sports officers through SDC. So you don't know what will happen in the future. I would have to amend if you decide in the future that you're going to use, and I'm just picking on SDC because often it's their officers that are used for some of this kind of stuff. Because they're there already, and you know, you can just train them versus hiring new persons or stuff like that. I'm just suggesting that we leave it open because right now it's closed.
That's fine with me, except that I'm wondering who would name the areas.
So Mrs. Coburn,
the minister?
So Mrs. Coburn, it would read, the minister with responsibility for gender affairs may designate persons as authorized officers for the purposes of ensuring the proper observance and compliance with the provisions of sections 3 and 4, and just leave it at that.
Yes.
That's fine, but that would mean minister to minister, because the minister can designate from the bureau because we're within the ministry. But that would mean a collaboration with the other ministries,
between ministers,
local government and so on, to get those officers in place and in the special units. Okay, so that's perfect with me.
And then now you'd have to, in tandem with what is contained in 2, ensure that they, sorry? Oh, Ms. Grant?
Yes, Chair. Sorry, I'm so sorry to disrupt you, Chair, while you were speaking, but just on this point, before we get a little further off, I don't agree that we should leave it open. I think we should let it remain closed. The whole purpose of this legislation was to designate a specific entity that is supposed to work in tandem with the legislation. That's the same reason why the Bureau of Gender Affairs will also act as a secretariat to assist the tribunal. And I don't think we should, I hear what Senator Rodriguez has said, and if such a situation comes up, then the necessary amendment will just have to take place. But I don't think we're at that stage now, because let us not forget that within the next 18 months after this legislation comes into focus, there will be a review period. It's not necessary at this time to leave it open, and it's going to so change the policy prescription that the ministry would have used to create this legislation. If we go now to say, okay, let us leave it, let's leave it open and not close it. So I just wanted to make that interjection.
Can I get some clarification? What would have to change for us to leave it open? You mentioned, I don't remember your exact wording, that something would have to be changed to allow that to happen. Because does it hurt the objective of the clause to leave it open?
Strictly speaking, I can see why you'd want to leave it open for the reasons that you have given. But also going back to the principal reason why it was so designated in the first place was to utilize these persons that would have the experience, that would be given the requisite training, that would be more adept at identifying these kinds of issues as opposed to an ordinary officer so attached in another division or organization. And so that was the thinking behind taking them and attaching them to the Bureau of Gender Affairs, because this is the entity that really would have the expertise in readily sifting through these matters that would so be qualified or classified as sexual harassment.
But if we open it, it doesn't prevent that from happening. But if we open it, nothing prevents, none of the wording prevents what you're saying is the objective from happening. But what if there are no funds to have these specific persons in place? We know we're in a pandemic at the moment. So I'm dealing with the 18 months that you're mentioning. We're in a pandemic. Do we then pause and not even have something happening versus just opening it so that if there are no funds to have designated officers, you can at least utilize what currently exists to help until the funds are available to have the designated officers?
But that consideration needs not even, that consideration doesn't need to be entertained, because I mean the issue of funds, that's not an issue that is there. But just to say that if I was to take that reasoning, then I could also say, well, let us not designate the Sexual Harassment Tribunal as a specialized tribunal. Let us just, in the event, utilize the IDT, and then until we are so in place, then we go ahead with the Sexual Harassment Tribunal. I'm just saying it's not.
You could, but I'm saying we've already passed that hurdle. We've already passed that hurdle, and we know that the Gender Bureau is understaffed. It needs more manpower. So what we're doing, if we keep it as is, we're saying then that the work cannot get done because we don't have enough people, while there are times when ministers...
No, Senator. No, it needs more manpower, as is the cry for every organization, every government agency.
Exactly.
But these are persons that will be so designated and so employed, as the case may be, to carry out these functions. So I'm saying it's not an
Well,
issue.
what do we do if we don't have that money right now?
Well, let me...
Do we close it and not have the officers?
Let me just say this.
Yes, Chair.
Let me just say this. You see, I am not of the view to have it. I see the minister calling me, so let me just... Chair, the real
Well,
chair.
while you take the call, I just want to pose a question to the persons from the ministry who might know how government functions. The clause says persons being field officers attached to the Bureau of Gender Affairs. Is there any way in which, for example, if the situation arises, as Senator Natalie Campbell-Rodriguez has pointed out, could there be an attachment of somebody from the SDC to the ministry, for example? I'm asking.
I'm sorry, go again, Senator Marley.
Okay, so it speaks to field officers attached to the Bureau of Gender Affairs. I'm saying how the government functions and the different agencies function. If, as the situation which Senator Natalie Campbell-Rodriguez has described arises, could an officer of the SDC, for the purposes of carrying out this task, be deemed to be attached to the Bureau of Gender Affairs? Is there that scope within how government functions?
So if I'm understanding what you're saying, so an SDC officer could still, what you're putting forward is a situation where the SDC officer, though not attached to the Bureau, would be performing the functions.
No, I'm saying, is there a mechanism by which they could be deemed to be attached to the Bureau for the purposes of carrying out this function?
Outside of a secondment? Are you saying outside of a secondment?
It might be a secondment. It might be that.
Okay.
And remember that recently we had a secondment from somebody, Mr. He has a very unusual name, which I forget now, who headed up ODPEM. He was on a secondment to carry out that task. All I'm trying to find out is if in these circumstances, to meet your concern, because I think it is a legitimate concern that you might not, we don't know how this is going to evolve and how many people will take advantage of the legislation immediately. So I am trying to address your concern without having the clause changed in any way because I understand the concerns that Ms. Grant is raising. So what I'm really trying to do, as Senator Gale will know, I'm always in search of a solution.
Yeah.
You're a mediator.
That's what I'm trying to do now.
And you have been very conciliatory this morning. But here is my no man, it come out even stronger where you have found solutions for us this morning. But here is my take on it. I particularly am not encouraged to have it opened in the legislation because I am of the profound view that the ministry and the bureau must determine in the first instance the staffing requirement. And I have a little concern, however, where from another entity, you have employees with defined duties already in that entity to be expected to take on responsibilities in another entity. I would prefer that within the 18 months that we have, if the need arises, then ministry to ministry can make that determination that if they need additional support, then the additional support can come from somewhere else, and those personnel would go through the requisite training to do so. One of the things that always drive me in a unique entity, and I consider this, the provisions that we are pursuing here to be unique, is where you always have persons with a commonality of interest operating as one. So these authorized officers that are going to be designated, they have a common interest. They are together, they are working together constantly, they are sharing information and ideas constantly, and so that would enhance how they operate. It is if the need arises, then we may have to go there, and that's a determination that we can make if and when. So I'm mindful of the concerns that have been raised. They are legitimate concerns, but I would want to suggest to the committee that we don't have it open-ended in this instance. But we can always make a determination later on. That would be my recommendation. Ms. Grant, you think you can work with that?
Yes, Chair, I agree with you. So it's, and it goes back to what Senator Scott Marty said about, you know, the ministry will make that determination, but as it is, the question that we're originally considering that it should not be open, the clause should remain as is.
Yeah. Okay. Cecilia Brown?
Yes, Chair. So I continue now with subclause 5.
Mr. Chair, you're not asking me what I feel since I'm the one who raised it.
Oh, I'm so sorry. Thank you for dragging me back there.
Yes.
You always do.
I disagree, but I will not hold up the committee on this bright Friday afternoon, but I want the records to reflect that I disagree, because having worked with SDC myself and seen how when ministries then have to come and try to use SDC officers as they are there to be used, I really just think we're putting ourselves up to having to amend a law in case you don't have the money within the ministry to hire these designated officers. You could use up what exists. You know, you can develop a cadre of NYS officers who work within this until you have the full resources. But I will stand down on the issue, but I don't agree.
But when you look at it again, you know, when you look at it again, sorry, Madam Chair.
Sorry, you continue to chair, but I just wanted to intervene here in that we have MOUs and relationships with many government entities, including the JCF. And so our relationship with the SDC will be strengthened. It does not have to be put in the legislation.
Minister was asking for it to be put in.
That's a network. The SDC is part of the network that we work with, and as the need arises, whatever is necessary, their skills and expertise will be drawn on.
Absolutely, Minister. And that's not what I'm saying. You know, what I'm saying is it's written here in the Act that the officers have to be attached to the Bureau of Gender Affairs.
I think you need to recognize, member, this is a specialized area. This is a new piece of legislation. People are going to have to be specially trained, etc., etc., etc. This piece of legislation will be reviewed after a period of time. And so at the time of the review, if it is necessary to make an amendment in this area, it will be so done. All right?
Noted, Minister.
It will be reviewed. And so an amendment to the legislation at a future date could take this into consideration as well. All right? Thanks, Senator. Mr. Chairman, please continue to act, and then I will join at some time within a half an hour or so.
Okay, Minister, I operate under your instructions.
Thank you so much. Thank you.
All right. Mrs. Seeley Brown.
Yes, Chair. So I continue at subclause 5. For the purposes of carrying out their functions under subsection 1 and without a warrant, enter any place of employment or institution in order to ascertain whether the provisions of sections 3 or 4 are being complied with. B, inspect any place of employment or institution to ensure compliance with the provisions of sections 3 or 4, or C, inspect and take copies of documents and other information or require any person at a place of employment or an institution to provide such information as may be reasonably required for the enforcement of the provisions of this Act. 6, a person who A, willfully obstructs or assaults an authorized officer in the exercise of any function or power under this Act, or B, fails to comply with a lawful request made by an authorized officer, commits an offense and shall be liable on summary conviction in a parish court to a fine not exceeding or to imprisonment for a term not exceeding. 7, an authorized officer on finding that an employer or person in charge of an institution is not in compliance with sections 3 and 4, it should be with section 3 or 4, with the provisions of, with any of the provisions of, so it should be not in compliance with any of the provisions of section 3 or 4, may issue a direction setting out the terms of compliance and the time not being more than 30 days within which the employer or person in charge of the institution shall comply with the direction. An employer, subclause 8, an employer or person who fails to comply with the direction issued under subsection 7 commits an offense and shall, on summary conviction in a parish court, be liable to a fine not exceeding $1 million. Now, Chair, there are 2 things there to consider. You would see my footnote in relation to subclause 5, where I asked the committee to note for the purposes of this Act at a place of employment may be a private residence, so that the committee needs to consider when you look at this whole issue of with or without a warrant. And because we have inserted that new offense in relation to subclause, in subclause 6, we needed guidance as to what type of penalty the committee would think would be relevant, would be sufficient in this regard. So where we just need to note the and try to just fill up clause 5, subclause 5, and subclause 5, subclause 5A, and the end of subclause 5.
So let's deal with A, with or without a warrant. What's the normal procedure here? I
would yield to the AG Chambers Chair. My only concern is I don't know how, because of constitutional right, you can enter somebody's house, I don't know, without a warrant. So remember
And this is simply because the place of employment may be a private residence.
Sorry, remember that? Yeah, I remember, Chair, domestic workers are included as workers. Sorry. So I just would like us to have some discussion on that, Chair.
Chair, just to give our opinion from the Chamber's perspective,
Yes.
we were a little concerned about that as well. And so we think that a warrant would be necessary in that case, especially in light of the fact that it may be a private residence. We definitely would be in support of with a warrant, not without a warrant.
So are you suggesting, just from my understanding now, are you suggesting that we make it specific that the warrant would be required only if it's the place of employment is that of a private resident?
I think generally it should be the practice. In this case, I think we should require it.
Yeah, I understand the requirement, but not the requirement overall. Is it specific to because the place of employment is that of a private residence?
No, I'm saying that generally, I think we should require a warrant for entry.
Yes.
But I was just saying that the point is even heightened because of the fact that we may be dealing with residential accommodation as well. But I think generally we would prefer that we go with a warrant just because privacy, constitutional rights, we don't want to have any issues in that regard. So we would prefer to go with requiring that a warrant be obtained in this regard.
Okay. Members?
May I make a comment to support
Yes.
the fact that a warrant ought to be required? It is only in exceptional circumstances that you permit a search without a warrant, usually when you're suspending the human rights of a person, because the Charter of Rights specifically states that people have a right to privacy. And if you're going to breach them, regardless of where it is, you really ought to have a warrant.
All right. Any other comment? So we can agree with the insertion of.
So we delete the words or without, Chair.
Yeah.
Yes. And then, Chair, the issue of what type of what is the penalty that you're proposing?
Yes.
Subclass 6, Chair.
We had made some penalties later on. Do we have a consistency?
Georgette, you want to help me, please?
Sure, with the penalties, the ones that were agreed for 37.4.
Yes.
We had, sorry about that, 500,000, 1 month, 1 million. I think I saw there's something in another section about maybe 50,000 or something like that. So that is what we agreed, Chair. We could draw on I forget the act right now, but I remember the Solicitor General had brought it up that we could use it as guidance in coming up with the respective.
You want us to just flag it and give you some time and we move on. We can move on, Chair.
Yes, we can do that.
So we can always fill that gap. Yes.
Yeah.
Yes. Okay. All right. So then we move on now, Chair, to.
Sorry, Mrs. Sullivan, can I just make one more interjection?
Sure.
Okay, for paragraph 5C, where we talk about inspect and take copies of documents and other information, if you could just carve out a provision just to exempt, because we can't just make persons copy documents that are subject to legal professional privilege. So we just need to have some kind of carve out there, some kind of wording just to exempt those documents.
You've broken up, Carissa, I didn't hear everything that you said.
Okay, sorry, let me try that again. I was saying in subclause 5C,
Yes.
where we talk about inspect and take copies of documents.
Mhm.
I just wanted you to make a special exemption for documents that are subject to legal professional privilege. Just to say that, you know, those would have to be exempt. Persons can't just come in and make copies of those kind of documents.
So you'll want me to insert another paragraph?
Yes. Please.
Okay, okay.
Thank you.
All right.
Okay, so that would I would insert that chair in the list of in the amended list, updated list of amendments that we would
Amendments, right.
Yes. That's if the committee agrees, Chair.
Committee members? I guess they agree.
Agreed.
Okay. Okay, Chair. The next amendments now, Chair, we on to part 5, the Sexual Harassment Tribunal. So it's the old clause 11, new clause 13 as renumbered. And we did a tidying up of the schedule because we've now inserted a first schedule. The schedule that we're referring to would be the second schedule. So that is seen in the first amendment to the marginal note. And then we have deleted subsection 2 in the chapeau and substituted for subsection 3 because we put in another subsection. And then in compliance with your instructions, you wanted the committee wanted the membership increased from 12 to 14, and we have done that by deleting the word 12 and substituting there for the word 14. And then you had wanted us to insert some other areas of experience and qualifications, which we have done in paragraph C, which I would read into the record. Delete paragraph C and substitute therefore the following. The other members who shall be selected from among persons who appear to the minister responsible for gender affairs after consultation with the minister responsible for justice and the minister responsible for labor and social security to be qualified as having had the experience of and shown capacity in matters related to worker representation, gender affairs, mental health, employer representation, and labor relations. So once that is agreed on, Chair, we can move on.
Members? I take the silence as agreed.
Okay. And then we are now syncing this clause with the fit and proper eligibility requirements, which we had outlined in subclause 2. So we are inserting a new subclause, a subclause 2 to read, a person shall not be appointed as a member of the tribunal unless the person satisfies the fit and proper eligibility requirements specified under section 2.5. And as a consequence of that, we've renumbered the current subclauses 2 and 3 as subclauses 3 and 4 respectively. Should I move on, Chair?
Yes.
Right, so we now move on to the old clause 12, which is clause 14 as renumbered. And I remember the committee instructing the technical team that you wanted provision to be made for the appointment of the deputy chairpersons of the tribunal so that you could have them chairing different hearings. You could have simultaneous hearings, and as such, you have inserted, we have deleted that provision and substituted there for the following, which I would now read into the record. Appointment of chairperson and deputy chairperson of tribunal. The minister shall appoint one of the attorneys at law who is appointed as a member of the tribunal to be the chairperson of the tribunal and 2 other members to be deputy chairpersons of the tribunal. Subclause 2, in the absence or inability of the chairperson to act in any of the tribunal, in any sitting of the tribunal, one of the deputy chairpersons shall act as chairperson at that sitting. And our query, Chair, is whether you would see the footnote. It is not clear whether the deputy chairpersons are to be attorneys at law. In addition, will it now be the policy that a deputy chairperson acts in the absence of the chairperson at sittings of the tribunal? So even though I've inserted subclause 2, which reflects that, I just needed clarity from the committee, that the deputy members who are appointed are they to be attorneys at law, and to whether that provision that speaks of the deputy chairperson acting in the place of the chairperson is appropriate in this regard, Chair.
How many persons we designated as attorneys at law?
4 members, Chair.
4.
Yeah.
And so if we have panels or divisions of the tribunal, then each of those panels or divisions can have a chair, an attorney at law to be a possible chairperson.
Mm-hmm.
So the deputy chairpersons who chairs a particular panel would be, in this case, an attorney at law.
So you're saying then that the deputy chairperson, which I understand, and the 2 deputies shall be attorneys at law?
Coming out from the 4.
Yes. That is what I wasn't clear on, Chair.
Well.
Because remember there
Do we
was
have enough? Do we have enough attorneys?
Sorry, Chair, we had Senator Rodriguez, Campbell Rodriguez, we do, because there are 4 members who shall be attorneys.
Right.
So if you've taken one Senator Rodriguez to be the chair, and you said 2 others shall be deputies, you still have 1. You have enough, if that is the policy.
I do not feel it is necessary, but if that's the feeling of the committee, I'll support it.
Sorry, I missed that, Senator Campbell Rodriguez.
I'm saying personally, I do not believe the deputy chairs have to be attorneys. However, I'm willing to support what the committee wants in this instance, but I don't think it is necessary.
Any other comment from members? Members?
Chair, I agree with this suggestion that the deputies, if you're going to say that the chair is an attorney, then the deputy should also be an attorney in the event that for any reason the chair can't be there. And I know that the fact that the chairmen were made attorneys was actually a policy decision.
Right. And so we would, you see, I agree with the standpoint where if the chair is an attorney, then to give the same standard to the other panels would be important. And then we would have sufficient attorneys among the number of representatives to sit on every panel. So I would work with that.
Chairman,
yes.
through you. My concern regarding the content of the committee members and the background is, of course, would be more of the awareness of my area, where there is the appreciation of the level of potential impact with respect to the damage that the victim may perceive, that a professional can appreciate. And this is why I had indicated the presence of mental health professionals, at least 1 or so on the actual committee. I think the same should obtain, that it should be so equipped that each subcommittee, each subgroup also has that level of representation. So with respect to the attorneys, if it is a policy decision with respect to it being chaired by such, yes, I would imagine that the deputy should also be. but, or the deputies should also be. But my concern is the representation at the level that personnel who are au fait with the mental health impact of sexual harassment is properly appreciated. And that is my concern around this subject here. Thank you.
One of the things you see in this situation is that so we'll have included in the tribunal members, specific skill set, gender affairs, labor relations, employee representatives, worker representatives. And so you run the risk of having on a particular panel the need or the call for a specialized representative. The good thing about what we have brought here is that there is in fact a representative of a particular area that can always be cross-referenced. Tribunal members share information, and they share ideas and they submit recommendations if they are called upon. So I believe we have.
Chair, I think whatever policy decision it was to have the critical role of attorneys being represented in the way that we are seeking to represent them, I think the same obtains for the mental health professional or the person who can professionally recognize the impact of the damage on the victim. So just as how there is, for me, in my mind, the issue of sexual harassment, there is the legal requirement and the legal justification that is required. But what is critical is the appreciation of the level of damage. So for me, it goes hand in hand that just like how you're pursuing justice through the legal arm and ensuring such, you have to pursue the level of damage and appreciate such and ensuring such. But I know, again, we will be having a review process and perhaps it will come up at that point. But I have to recognize that the victim's level of damage in any and every case that is going to be reviewed by the tribunal should be fully appreciated as best as possible.
All right. Point taken. Noted.
Excuse me, Chair.
Yes.
Member Sibley has had his hand up for a while.
Oh, thank you. Welcome, Member Sibley. I'm not seeing the hand raised.
Thank you very much, Chair. I was trying to butt in as well, realizing that you're not seeing the hand raised, but my voice did not carry.
Carrying now, my friend.
Thank you. Chair, I am in agreement with the policy with regards to Deputy Chair being attorney at law. I'm also in agreement with the with Senator Longmore, and I think we had discussed the point raised by Senator Longmore, and I'm aware that all these skill set would be very important in putting a panel together. And Chair, so I am in support. Thank you.
Thank you, Member Sibley's. So, Mrs. Celia Brown?
Yes, Chair.
We're okay with that now?
Yes, I'll make the necessary changes to subclause 1, Chair.
Right. So you now move on to?
We now move on, Chair, to, well, there was just some tidying up of the other provisions.
Yes.
In respect to clause 15 as renumbered, which is the old clause 13. So there was a subsection, there was a 1 in front of 13, and you realize there's no subclause 2. So we took that out, and we have just amended the sections within the body of the clause to make it in sync with the insertions that we would have made earlier on with respect to the jurisdiction of the tribunal. So that's just basically tidying up of clause 15, Chair. Then we
Okay.
move on, Chair, to clause 16 as renumbered, which is the old clause 14. And you had instructed us to delete the clause, and I'm trying to remember what was the rationale for this, Chair. I'm reading it to see. Right, it would have stemmed from what I was questioning before. So I came up with two constructs, which I will read, and then you will tell me which one is appropriate. A complaint made to hearing of parent panel of tribunal. 16.1, a complaint made to the tribunal pursuant to section 15 shall be heard and determined by a panel consisting of 3 members of the tribunal. Subclause 2, at least one of the members of the panel shall be an attorney at law who shall also be the chairperson of the panel, or a deputy chairperson appointed pursuant to section 14.2 shall be the chairperson of the panel. 3, in appointing a panel pursuant to subsection 1, the chairperson of the tribunal shall at all times ensure that there's a gender balance amongst the membership of the panel. Subclause 4, in assigning members to the tribunal to the panel, the chairperson of the tribunal shall take into consideration the necessary experience and expertise that are necessary to enable the panel to determine the issues raised in any matter before it. I think, Chair, we can now go with the last subclause 2, 3, and 4. Now we have agreed that the attorney at law would chair the panel, and that covers the other issues I think that was raised about having gender balance and who are the persons that you would appoint to these panels. So obviously depend on the nature and the type of the complaint.
And the type of complaint.
Yes.
Next.
So you're happy, Chair?
Yes.
Okay, all right. So now we move on now to clause 17 as renumbered, Chair, and I think you had raised these issues with respect to at the time of which an interest in a matter could be disclosed, Chair, and we were instructed to redraft that provision. So I would now read it into the record, delete subclause 1 and substitute therefore the following: a member of the tribunal who in any way, whether directly or indirectly, has an interest in any matter that is brought before the tribunal shall A, by notice, declare the nature of the interest on the first opportunity on which it is practicable for the members so to do, and B, not take part in any deliberations or decisions of the tribunal with respect to that matter. So that is what the team came up with, Chair, for your consideration, for the committee's consideration and approval.
Well, since I raised it, I'm in support of what is prescribed here.
All right, Chair, if there are no other queries in relation to that, we're moving on to clause 19 as renumbered, which would have been the old clause 17, which dealt with acting appointment, and you wanted us to ensure that whoever is appointed to act is somebody of the same competence as a person for whom they are acting, and so we were asked to redraft that provision. I will not read it. I'll not read it into the record, Chair. Acting appointments, clause 19. The minister may appoint any person to act in the place of the chairperson of the tribunal or any other member of the tribunal in the case of the absence, inability, or refusal of the chairperson or other member to act. So, however, that such appointment shall be made in the same manner and from among the category of persons as would be required in the case of the original appointment. So that takes care of clause 19, Chair.
Right.
If there are no queries.
Any members?
Nope.
All right.
Okay. Yeah, in clause 21, Chair, where we speak of the disqualification, and I think that will take care of the point that was raised by Senator Rodriguez. Clause 19, disqualification to be left A, Chair, because that is necessary, but we took out B, C, and D and inserted instead, sorry, Chair, right. The person does not or no longer satisfies the fit and proper eligibility requirements under section 2.5, because we have now done this fit and proper test, requirements, Chair. There's no need to state it as B, C, and D. We just said that, we just link it back to section 2.5 of the Act, as those whatever is there is listed already.
Hold on, Miss Grant. I was looking at the, go up a little. A person shall not become or continue to be a member of the tribunal if the person, okay.
Saying that they would have taken care of the concerns raised by Senator Rodriguez. And
right.
we did BC&D because BC&D now fits into that whole eligibility requirements under Section 2.5. So we just put it to the provision to link it back to that, which reads does not or no longer satisfies the fit and proper eligibility requirements under Section 2.5. So
all right.
If members are happy with that, we can now move on to clause 27 as renumbered, which is in part 6 of the bill, which deals with making of complaint. And you have asked us, basically, you would ask us to redraft that entire section to take into consideration certain things that you would have wanted to see in the legislation. And I will now read it into the record, Chair. Clause 27, making of complaint. Subclause 1. A person who alleges that A, an employer or a person who is in charge of an institution has failed to comply with Section 3.1 or 2. B, a contravention of Section 5.2, 6.2, 7, 9, 10, or 11 has been committed against the person. Or C, an employer or a person in charge of an institution has disclosed information in contravention of subsection 4. That or, Chair, should come after C and not after B. Or D, he or she is aggrieved by, not satisfied with, the findings of the employer or a person who is in charge of an institution, as the case may be, pursuant to a sexual harassment claim made under Section 5 or 6, may make a complaint in writing in the prescribed manner to the tribunal, setting out the details of the alleged contravention. Subclause 2, a complaint shall be made A, in the case of subsection 1B, and Chair, I need to stop here to tell you why we have had to do it, we have drafted it like this, and what are the concerns that we've raised. Remember, we're dealing now with the time period for which a complaint can be brought before the tribunal.
Yeah.
I can understand us using 6 years, Chair, in the case of subclause 1B, because those all deals with the alleged contravention, the alleged acts of sexual harassment. But when it comes down to, Chair, to subsection 27.1A, C, and D, we are just, the technical team is, we're just concerned that the limitation period might be a problem in relation to the 6 years. So that is why we have drafted it the way we have and have left, we have subdivided it and left some things in square brackets for the committee to consider. So in that light, I would read subclause 2 again. A complaint shall be made A, in the case of subsection 1B, within a period of 6 years from the date of the alleged contravention, or in the case of a course of conduct of series of alleged acts within a period of 6 years from the date of the last alleged act, and B, in the case of subsection 1A, C, or D, within the period of dash from the date of the alleged contravention. So we are going to have to determine how long are you going to give that person to bring that claim if it is not an actual sexual harassment claim as is set out in paragraph B.
All right.
So move on, or do you
don't
move on.
Don't move on. So let us deal now with what D, because D jumped out at me. And this is where the person would be aggrieved by the result or not satisfied.
Yeah, so that is, Chair.
Which is a different scenario from the initial complaint itself.
That will be, Chair, because in a notice we have linked it to 5 or 6, which are the new insertions. So that will be a case where, for instance, an employer, a person is sexually harassed, and you make a complaint to your employer or the person in charge of an institution, and you are not satisfied. Remember, you wanted that inserted with the findings.
Mm-hmm.
Right, so then you must be able to make a complaint. You must be able to make a complaint before the tribunal.
Right, so this is where now you escalate to the tribunal.
Yes, after that sexual harassment claim had been heard by the employer or the person.
Right.
And because that is what you specifically wanted inserted and understood. Yes, Chair.
So in another legislation, the LRID, there's a 12-month, since 12 months since the occurrence occurred, that the matter can be heard before a tribunal. And I believe there was a particular case that triggered that. So in 2B now,
Yes.
this is where you want to have that defined period.
That's 6 years, and subject to further down where the tribunal can, in exceptional circumstances, grant you an extension of that time. So from based on what you're saying, Chair, you are proposing, of course, subject to the approval of the members of the committee, that in the case of paragraph D, that one must be made 12 months after that sexual harassment.
Right. It would have to be a less period, because this now deals with the outcome of the hearing.
Yes, Chair.
And so you're escalating it to the tribunal, and you have to escalate it with the tribunal for the shortest possible period.
Yes, Chair. But then also, Chair, you have A and B, which are a little ticklish, because this A deals with where the employer or the person in charge of the institution has failed to, I think it has to do with the sexual harassment policy.
Yes.
And so in that case, we would want to know what time frame you would want, because obviously it can't be 6 years for that one. And for C, where the employer has disclosed information in contravention of 4.4, because remember in 4.4 we said in the policy that the information must be kept confidential. So you're going to need, I'm saying to you, Chair, the time limit, you're going to need different time limits for different limbs of this provision. And that is what we want the committee to address its mind to, so that we can be guided in draft.
But these time limits now are shorter than the 6 years.
Well, we are thinking it would have to be, Chair, but we are guided by the committee in that regard. Because remember before, everything was 12 months. And then when we picked it apart, and quite rightly so, you wanted a longer period for a sexual harassment claim, which was 6 years. We never considered all of the other complaints that can be made.
That can be made. All the other attendant complaints.
Yes. So the committee has to now address its mind to those other areas and instruct us as to the time frames you would want to give a person to bring that particular complaint to the tribunal.
And these are what you would call now, in my mind,
paragraph A, for instance, Chair, if I take you back to clause 3, 1 and 2, paragraph A deals with where he shall take reasonable effort to ensure that employees are sexually harassed. That is the employer. If you look at clause 3, 1 and 2, and then the person in charge of an institution. So a person can bring a claim if that person doesn't think that the employer took reasonable effort to ensure that he or she wasn't sexually harassed. You need a time frame for that. So that will be the new 27(1)(a). And then if you look at clause 4.4, where the policy statement gives a duty for, is it 4.4? Let me look and see. 4. Is it 4.4? Yes, right. Where you disclosure of information. Says section 4.4, an employer or person in charge of an institution who discloses information shall be liable for such disclosure. So that would be subclause 1C of clause 27. So we need to determine what are the timeframes for those, for bringing those type of complaints before the tribunal.
Members? Any comments?
Chair.
Yes, Senator Scott.
When you look at it and you realize what the allegations would be, I am of the view that the time frame would not have to be extraordinarily long. It would go nowhere near the 6 years that we have established as a cutoff point for making this complaint. I do believe that since it speaks, let's take, for example, the failure to comply or the contravention of the requirement that you don't disclose. I think that if we were to look back at the 12 months, which was contemplated for this, then it would give every opportunity to someone to take action where they feel that there has been a breach or somebody has failed to act under
Or
the
they have been
policy.
deprived.
Pardon me?
Or they have been deprived.
I did hear. Or they have been, yes.
Yeah.
And I would like to hear, I wonder if the other members of the committee could comment on that.
Could comment
Because
on
that was what was contemplated at the outset. Even while I say so, Chair, I'm going to be departing from you soon. And I have to extend apologies from Senator Fraser Binns, who does not feel she will be able to rejoin.
Oh. Ms. Mark,
before Senator.
One second, Senator Campbell Rodriguez. Ms. Mark, we're still having quorum?
But I saw MP Sibley's join, so I didn't feel that my absence would have created any kind of dilemma, Chair.
All right. Yeah, yes, Senator Campbell Rodriguez.
Yes. Thank you, Mr. Chair. There's a jackhammering sound at someone building a street away from me. So I missed some of what Senator Scott Motley had said. Right, and let me just apologize in advance in case anyone is hearing it. But are we saying we should go back to the 12 months? A complaint shall be made?
No.
Within 12
No. What we're saying here,
sorry. Go ahead, Chair.
What we're saying here is that there are some attendant causes to which complaints can be made coming out of the process itself that was triggered, where someone might not be satisfied of the outcome, or where in instances where the actions of the employer did not meet with the requirement of the legislation. And so the matter ought to be triggered to the level of the tribunal as a complaint. It's not the 6 years and by extension, the additional 2 years that we have already agreed on for the complaint itself, but these attendant causes.
Okay.
And so what we need to do is to define what those periods ought to be. And I'm asking Mrs. Seeley Brown if for these instances, we can have a standard application of a defined period.
So you're saying in Chair, in terms of paragraphs A, C, or D, you would go with the 12-month period. That's what
I'm asking, if the standard the standard defined period could work.
Yes, Chair.
Because it makes it easier as a reference to the legislation rather than we're all over.
Yes, Chair. Chair, I see Ms. Simon hand is up.
Yes. Ms. Simon.
Yes, Chair. It was just a query. Since D, though, is kind of related to a claim, wouldn't you think that maybe that period should still be the 6 years, since what they kind of would be doing is looking at the claim again, if in a sense?
No, because I don't agree, Eric, Ms. Simon, because he's not. Remember that he's not satisfied with the findings.
With the findings or the outcome.
Yes. You remember the sexual harassment claim would have been heard by the employer. And I know, I just wondering. So I don't think we want to extend that for 6 years.
No, my reading of this, and I remember raising this, was that the complaint would have already been made. Yes. Irrespective of what. If it's 6 years or 8, the complaint was made.
Yes.
And so the matter would have been handled. Well, not the 8 years, because it's only when the tribunal have to make that determination.
Yes.
But after the 6 years, the complaint would have been triggered. In D, what D is suggesting is that he or she may have been aggrieved or not satisfied with the findings of the employer or a person in charge of the institution. And as the case may be, pursuant to sexual harassment claim already made in 5 or 6.
Yeah.
So in this instance, based on the outcome, John Brown or Mary Sue may feel aggrieved or not satisfied. And so they have within a defined period, and what we're suggesting here is 12 months to make up your mind.
I get you. I follow.
Okay.
I had a little doubt, but I understand.
Okay.
I'm sorry.
Sorry?
Remember,
Yes.
that would give impetus to the employer to act. And that is part of what we are trying to achieve, that we have the employer acting in a timely way. So that if there is the failure, the internal, the dissatisfaction with the internal issues, the fact of any disclosure, all these are factors which would be enable the person to go to the tribunal. So in a way, what they do is put pressure on the employer to comply, which is, I thought, one of the objectives that we have.
Yes, clearly.
Yes, Chair. So, and Chair, and in relation to paragraph D, the committee prefers the words aggrieved by or not satisfied with. Which terminology would you prefer to see in the legislation? 27D. He or she is aggrieved by, not satisfied with.
Could it be both?
I would leave both.
Leave both?
I would leave both.
Okay. Aggrieved by or not satisfied with. Okay. Excellent. Yes, Chair. So I'm going to go on now to read subclause 3, which says that notwithstanding subsection 2, it should be subsection 2A, the tribunal may, in circumstances which it considers to be exceptional, grant leave for a complaint to be made after the period specified thereon. Now, Chair, is it that you would only want leave to be granted in the case of subsection 2A, or would you want leave to be granted in the case of subsection 2B? So for instance, if 12 months have passed and a person still has exceptional reasons why he didn't bring that complaint on this paragraph A, B, or D on the subclause 1, will you still want to be able, do you still think that that person should also be heard by the tribunal in exceptional circumstances? Or should it only be when it comes, but in relation to...
Again, this don't carry in my mind the same gravity of the mental strain as us moving with the 6 years. That carries a different weight. In this case, both the employer or the person conducting business would also want the matter to be closed.
Okay. So it should only be, so this exceptional, this extension should only be in relation to 2A, which deals with complaints on 5262, everything that deals with a sexual harassment complaint.
A sexual harassment complaint,
okay,
right.
So we move on now to subclause 4. Subject to subsection 5, a person shall, before making a complaint under subsection 1B, exhaust the use of any internal mechanisms and procedures that are available to the person as provided for in a policy statement issued by an employer or a person in charge of an institution, as the case may be, in accordance with this section. Subclause 5, the tribunal may grant leave to a person to make a complaint to the tribunal in the circumstances provided in subsection 6, notwithstanding that subsection 4 has not been complied with. Subclause 6, the circumstances referred to in subsection 5 are that the tribunal is satisfied that the person has A, shown cause as to why the person reasonably believes that the person's rights may be prejudiced if the person were to comply with subsection 4, or B, provided evidence to show that no internal mechanisms or procedures or no adequate internal mechanisms and procedures have been made available to the person as is required under section 43D.
Question, Mr. Chair.
Yes.
Subsection 4, which says, subject to subsection 5, a person shall, before making a complaint, exhaust the use of any internal mechanisms and procedures that are available to the person as provided for in the policy statement issued by an employer. I have a question there. It goes back to my earlier question from an earlier section. If the person who is accused is the employer, is the head of the institution, and in their, we spoke earlier and we said in that case, the person could go directly to the tribunal. What if in the policy statement issued by an employer, it states for them to do something differently rather than go straight to the tribunal?
No, because remember, Senator Rodriguez, we have made it mandatory. When we inserted that new clause, remember when we looked at that new section 7, that we had put in, we made it very clear. Make him, unless you want me to make it clearer. It says
sorry, you made clear.
Yeah, it says when allegation of sexual harassment is made against an employer or a person who is in charge of an institution, the worker, client, or student, resident, ward, inmate, patient, or member may make a complaint directly to the tribunal.
So you're saying what's stated in there supersedes what's stated here?
Yes.
Because here it is stated as provided for in the policy statement
Yes.
issued by an employer.
But I think I should make it clearer to say notwithstanding. Because you have raised that concern, it means that, you know, it is something that somebody else may have a problem with. So I could say notwithstanding section 4. Hold on a while, let me see what section it is. Notwithstanding section 4.3D.
Yes, please.
Yes, I can say that. Notwithstanding, in front of clause 7, Chair, I would insert notwithstanding the provisions of section 4.3D, so that it is clear that you don't use those internal mechanisms once the complaint is against the employer or the person who is in charge of an institution. So that issue doesn't arise at all.
All right, so that captures the other part of the equation that we would have missed out and captured earlier.
Yes. Ms. McCarthy, you have that? Do you have that?
Could you please repeat, Mrs. Seeley Brown?
So that will be on page 5, Mrs. McCarthy, of the list of amendments, where we inserted the new clause 6. Making a complaint. You hearing me? Are you hearing me?
Yes, I'm hearing you now.
Right, so it will be on page 5 of the list of amendments at the bottom, where we have inserted the new clause 6, making of complaint against employer and person in charge of an institution. So we'll start it by saying, notwithstanding the provisions of section 4.3D, where an allegation, and it continues.
Okay, thank you.
Okay.
So, Senator Campbell Rodriguez, I must say that you're very sharp with this one.
Well, this is such an important piece of legislation. I have to be on point today. Have to be, even though it's Friday.
Yeah, so that makes it clear that
right
to go straight to the tribunal. All right. Okay. So was there anything, Chair, we had to clarify in this one? No, nothing else. Yes. So if that's fine, Chair, we can move on.
Yes.
Okay, clause in the clause 28 as renumbered, which would be the old clause.
Mrs. Brown, just one quick interjection.
Yes.
With regards to that change that you just made, I don't think the reference should be to notwithstanding 4.3D. It should be notwithstanding 27.6, I think, because that's the section that says that you're supposed to exhaust the mechanisms, or you don't think, instead of 4?
27.6?
Yeah. No.
Because that relates specifically to 5.
27.4.
Yeah, that's
27.4. I'm saying, do you think it should be the notwithstanding 27.4?
No, I wanted to make it a little clearer. I wanted to make it a little clearer because even though we have that there, it's because that speaks to subsection 1B, and 1B, let's see. No, I would,
since it's 27.4, that says you must exhaust the internal mechanisms. I'm just wondering.
That's a different point though, because
okay.
I think, hold on, I think what Senator Rodriguez Campbell was saying, even though that is there, she still raised that concern. Even though that is there, the fact that she still raised that concern, that because of what the policy says, because you notice she linked it back to the policy, which says that you must, you must exhaust all of the internal mechanisms. And she's saying, what if within those internal mechanisms, there is some sort of policy which says otherwise? So I think, to be clear, we should just exempt that whole internal mechanism policy from stuff.
Then maybe it should be both, because 27.4 also says a person shall, before making the complaint, exhaust the use of the internal mechanisms. So maybe it needs to be both.
See?
That it's subject.
Well, we can, for avoidance of doubt, we can say both, but I wouldn't want to take out. Okay.
Yeah, I get you. I'm just saying, because this also says
okay,
the exhausting the internal mechanism.
That would be 27. Oh, okay.
Plus the 4.3D.
Yeah, for the avoidance of doubt, yes, we can put both, Chair.
Okay.
All right.
Are we clear?
Thank you, Erica. Yeah. Where was I now, Chair? I'm a little.
28.
28 as renumbered, which is the old, right? That is just a tidying up, Chair, because we have renumbered. We took out 25 and put in 27.
Okay.
Right, and then clause 29 as renumbered, investigation and reports. Right, because remember we had the whole thing up with authorized officers, so we had to tidy that up. So I would reread subsection 1. Subject to subsection 2, upon receipt of a complaint, the tribunal may cause an investigation to be conducted into the particulars of the complaint by such person authorized by the tribunal as the tribunal deems necessary and appropriate, having regard to the nature and the circumstances of the complaint. And we're saying that you're not using authorized officers as defined. We're not limiting the tribunal to the use of authorized officers as defined only in the act, but they must be able to draw from whatever group of experts or whatever expertise they be deemed necessary in hearing a complaint. Yes. Yes. Yes, and then the other item 20 are just consequential, Chair, of that amendment, so that you don't speak to an authorized person, but a person who is authorized an investigation, who can be an this act or any other person.
Right.
All right. And then now, so then, Chair, if that is accepted, we can move on to clause 30 as renumbered, which is the old clause 28. And I think the issue was raised here by members of the committee that you wanted the whole issue of frivolous and vexatious not to be determined early in the complaint, but allow the tribunal to hear the particulars of the complaint because of the nature of what we're dealing with. And so you ask us to redraft it to say just that. So we deleted the chapeau to clause 30, which is the old clause 28, lack of grounds for making of complaint. And I will now read that into the record. Pursuant to a report made under section 29.5, where the tribunal finds that there is no evidence of sexual harassment or the complaint is frivolous or vexatious, it should be, or a complaint is frivolous or vexatious, the tribunal shall, in writing, inform, and it stays as is, A and B, the complainant, and then the personal gain to the complainant was made. If that is accepted, Chair, we can move on.
Yes.
Right, and of course, clause 31 was another typo that we just took out late. And
Mrs. Brown?
yes, Ms. Simon.
I just had a little query on that point. I noticed in clause 29, it doesn't have the frivolous or vexatious as it did when it was clause 27. And I just wanted to know.
In clause what?
Clause 29 as renumbered in clause 29(1).
You mean clause 29 as renumbered is clause 31. That's the one you're talking about?
No, what is now clause 29? It was clause 27. The one that is investigation and report of findings.
Yeah, because we were told to take it out because the issue was raised that it was too early to determine that a complaint was frivolous and vexatious. The committee felt that because of the nature of sexual harassment, of the sexual harassment claim, you may want the investigation to be carried out. And then that determination, yeah. So those were out, yes. So that was the concern that was raised. And so they were saying that you should put it further on after the investigation was carried out, whether or not you should deem it there to be, whether or not it was frivolous or was well founded to continue that. But that was my understanding of the instructions as they were given to us by the
Okay, I was just wondering, because you only mentioned 30, you didn't mention 29. So
yes, because I took it out of. Didn't I take it? I should have taken it. It should have come out of.
You took it out of 29
yes,
as well, but
yes.
you didn't mention it. So I was just wondering.
Yes. That was the reason why.
Okay.
You satisfied with that, Chair?
Yes.
Okay. So we are now at clause 36 as renumbered, Chair, which is the old clause 34, which deals with the awards of the tribunal. And we were instructed to take out in subclause 3, in subclause 1B3, the words employ or re-employ and substitute there for the words reinstate. I think that was after a long discussion and concerns that you would have had, Chair, with the whole issue of re-employment.
Yes.
Or employment, right? And then we deleted subclause 1B4 and we lettered the renaming paragraphs accordingly, because you instructed us to delete 1B4. Sorry, 1B5. 1B5, Chair. Because remember there was a discussion that
it was 1B.
Right. And then you instructed us to delete subclause 2 today, but the whole thing about the mental and emotional, and incorporated that by deleting, read it into the record of what we are substituting it for. The tribunal may, in making an award under subsection 1B, take into consideration injury to the complainant's feelings and any humiliation, mental and emotional distress suffered by the complainant. Should it be mental and emotional, mental or emotional distress? Senator Longmore.
Senator Longmore, if you answer that one.
Is she still there?
I'm here.
Should it be mental or?
Yes, we had discussed it, and I think Senator Scott Motley also contributed to the fact that, you know, mental can also be cognitive and other, but mental could cover emotional, but the standard across legislation is mental and emotional. So let's go with
mental
that.
Or emotional, okay.
Yeah.
And then we were told, Chair, to delete subclause 4 and substitute the following. No, we just deleted subclause 4, Chair, of clause 36 as renumbered, which would be the old clause 34.
Right.
So if that is accepted, we could move on now to clause 39 as renumbered, which is in part 7, which deals with the penalties. And you ask us to reconfigure the penalties, and I'm going to read it in now subclause 4 and substitute there for the following. A person who A, interrupts the proceedings at the hearing of the tribunal, B, uses insulting language towards the tribunal when the tribunal is exercising any powers or performing any functions under this act, commits an offense and shall, on summary conviction in a parish court, be liable to a fine not exceeding $500,000 or, in default of payment thereof, to a term of imprisonment not exceeding 1 month. And then because we had to tidy it a little and link some offenses because they had the same penalties, we inserted after subclause 4 and do subclause 5, which says a person who publishes anything in contravention of section 35B, permits, divulges, or communicates any particulars of a complaint in contravention of section 28. C, furnishes to the tribunal any information or makes a statement at a hearing, knowing that the information or statement is false or misleading in a material particular, commits an offense and shall, on summary conviction in a parish court, be liable to a fine not exceeding $1 million or, in default of payment thereof, to a term of imprisonment not exceeding 12 months. If that is accepted, Chair, we can move on.
These are serious offenses, yeah?
Yes, Chair.
Very serious offenses. All right, we can move on.
Clause 40 as renumbered, right? So we just basically tidying up those also, Chair. Remember, we deleted 3 months and we thought that we should have used 12 months instead of 3 months. Happy with that, Chair?
Yes.
Right, and then to take care of the concerns that was raised, I think it was Member Rodriguez, the whole knowingly making up a false complaint. We redrafted that section to read a person who knowingly makes a false complaint under section 27 commits an offense. And then, Chair, we move on to clause 43, which deals with the 43 as renumbered, the tribunal to regulate its own procedures, and the committee instructed the technical team that you wanted the rules and procedures of the tribunal as first constituted and all amendments made thereafter to be published in the Gazette. Are you speaking though of, when you said rules and procedures, do you want both published? So the procedures as to how they will conduct their meetings and all of that, and the rules.
Is that normally published? In terms of, because they will change their own rules, you know, procedures, you know.
Yes, I could see us publishing probably the rules as to.
The rules.
Yeah, but I don't know if we should, I wasn't clear as to whether or not we were instructed to publish.
Because if you publish the procedures and the operational, you may have to amend the procedures.
Yes.
Is it required that you're going to have to publish it in again?
Yes, Chair, I agree.
So I'm thinking that it's the rules.
Okay, Chair. So I have deleted that, and clause 44 is renumbered, which would deal with the review of the act. Clause 42, you remember we said that we would change 5 years to 18 months.
Yes.
Right, and then Chair, I'm now at the insertion of the schedule, and I think I will let the ministry take over since this is the technical aspect of the amendment where they have now inserted sexual harassment workplace policy, Chair. I think that ends my, and of course I amended the memorandum of objects and reasons, just to bit which I've done. So here ends my presentation.
And that would include the new naming.
Yes, here ends my presentation. I now hand over to Mrs. I think it's Coburn Robinson to deal with the schedule as in the first schedule as inserted, which deals with the technical aspects of the sexual harassment workplace policy.
Thank you very much, Mrs. Brown.
Senator Longmore's hand is up, Chair.
Yes, Senator Longmore.
Yes, thank you, Chair. I just wanted to have on record with respect to the review process in 18 months, that the consideration for an issue that I had raised in the past regarding harassment. I know that we're not dealing with in a public space, But with the advent of technology and the use of video evidence, et cetera, that where such would be available for persons who may be able to prove such in public spaces, that we are able to consider that in the review process that is coming up in 18 months. And I would just like to put that on record here.
Thank you very much, Senator Longmore.
Thank you.
Ms. Simon?
Yes, Chair. I was just wanting to raise, I wondered if this was an appropriate time to raise some suggested penalties for that section with authorized officers, or if would you want to take it after? I had done some checks.
Well, since we are moving to the schedule now, let's take it now, no?
Okay.
Which clause is that, Erica? Erica, which clause is that? Sorry.
Yeah.
The authorized officer where they don't comply. Sorry?
Remember what page on the list of amendments? I can insert it one time. What page is it on the list of amendments, Erica?
Let me take a look.
Would that be 12.6, Miss Simon, the same one? No.
I'm just trying to bring it up.
Oh, it's on page 9. You're talking of page 9 of the list of amendments, the designation of authorized officers section.
Yeah, that the one with their pause.
Yes, yes.
Right, and you there's going to be a penalty if they don't comply.
Yes.
Oh yes, we had flagged
if
it.
they obstruct the authorized officer, that kind of thing.
Yes, yes.
Right, so I had done some checks and found 3 different acts that had provisions.
Yes.
The National Solid Waste Management Act, it's a bit older. It's from 2002 and it hasn't been amended. But in section 50, there is a penalty for, let me find it, for a person who willfully hinders or obstructs an authorized officer acting in the execution of his duties, and in B, without lawful excuses, fails to comply with a reasonable requirement of an authorized officer. D, personates or pretends to be an authorized officer. No, that one's not relevant. Or E, assaults, threatens, intimidates, or uses threatening language. The penalty in that section is $500,000 or 6 months.
Okay.
But, there is the Disaster Risk Management Act, which is newer, and in section 52 of that act, where for the assaulting or obstructing of the authorized officer or failing to comply with a requirement, the penalty is a fine of $1 million, not exceeding $1 million, or imprisonment for a term of 12 months. And that is also the penalty under section 25B of the Food and Drugs Act.
And those are more recent, you say?
They're more recent, yes.
The Food and Drugs Act is more recent?
The amendment, it was amended, Chair.
In 2011, and the Disaster Risk Management is the newest of them all.
So maybe, Chair, we should go with what the more recent amendment.
The more recent amendment.
What was it again? You said, Eric, it's not exceeding
not exceeding $1 million or the 12 months in the 12 months. Yeah.
Chair, Ms. Grant hand is up, and Ms. Cunningham from Parliament, her hand is also up too.
Right, Ms. Grant?
Yes, Chair. I was just on the same point that Ms. Simon raised. Myself and Mrs. Mesada, we were looking at different pieces of legislation, and we saw there was 3 million in one legislation, 100,000 in the older ones, but the more recent ones, the penalties are higher. So we were thinking that maybe given the scheme that we have set out so far in the legislation, being 500,000 for the offenses in 37, I don't remember the newly numbered section, but in the old what was 37, 500,000 or 1 million, that possibly the best prescription might be the 1 million, where such a person obstructs an authorized officer.
And give me the term.
give you the term. Oh,
So you gave us the fine.
1 million or 1 year.
Or 1
Yes,
year.
but,
Okay.
but not exceeding 12 months, Chair.
Yes.
Okay.
Yeah.
All right. Ms.
Chair, I don't
Cunningham?
know if you want to take Ms. Cunningham before you
Yes,
take.
Ms. Cunningham.
Yes.
Sure. Mine is a simple one. I was just looking at the list of amendments. You can hear me, right?
Yeah.
Where we have delete subsection 1 here at clause 12, shouldn't it just be delete the clause because we replaced all of clause 12?
Where
If
is
I
that?
understand-
Where is
Right
that?
on page 8, the
Page
description for clause 12 as renumbered. It says delete subsection 1 and substitute therefore for the following, but then it's the whole section 12 that we've changed as far as I.
No, I have delete the section.
No,
And
well,
substitute
the
therefore.
version of the list of amendments that I have says delete subsection 1 and substitute therefore the following.
Oh no, maybe it was I don't know, but mine says delete the section and substitute therefore the following. So
all right, no problem.
when I just when I send it back, you just make sure that is what. Thank you.
All right,
Anyway.
I'll double check.
All
No
right.
problem.
Thank you, Ms. Cunningham.
Chair says just the first schedule now.
So we're at the first schedule now.
Yeah, and then we would have come.
So who is going to take this?
It will have to be somebody from the ministry, Chair.
I leave it to Mrs. Coburn Robinson, Chair.
That sounds like a quick swing on the off stump. Ms. Rob?
So sorry, I wrote in the chat that I had stepped away from my desk to deal with an internal matter, so I missed the question.
Oh, no, Mrs. Corbett Robertson, we now just dealing with the first schedule.
Okay.
And the sexual harassment workplace policy that was inserted. I don't know if you had any comments or if you wanted to take the committee through what is the intent, what are the provisions and the intention regarding what has been inserted. That's just it.
Okay. Sorry, I have not had a chance to look at it. But if it is what was sent in terms of the...
It is what was sent. What was
template.
sent? Yes.
Yeah.
Okay, so that is fine because
That's
what
fine.
what we did was to use the template that we use regularly with workplaces that develop their own sexual harassment policy. And there we use the guidelines that are international and regional. And then they've picked it to match our contextual reality to make sure that they cover basically most of the areas or as many of the areas as possible so that the staff members will feel protected and that they understand that it's gender neutral and that it does not discriminate against any person, any group of persons, but that all persons are covered under the legislation. The policy, the guidelines. The policy itself, right. The policy itself, right.
Okay, Chair, well, if that's it, Chair, it's just for us now to do the minor tweaking of the provisions and submit the list to Mrs. McCarthy to be attached to the report.
Wait,
right. Yes.
Ms.
Yes, Ms. Grant.
I just wanted to say, that the first schedule is here on the screen. I don't know if you want to look at it or if you want. So in addition to what Mrs. Robinson said, just to talk through what the template looks like. Would you want that or you just want me to do it on the screen so you could see?
Well, you have it up there. So I gather members can read through.
Okay.
Is there anything for us to insert or amend as part of our proceedings today?
Oh, there was one thing, Georgette, remember?
Yes, I'm looking forward to right now.
Yes, there's one thing, yes, on page, oh gosh, where is it? Where we had committee.
On page 16.
No, to substitute, right, yes, right. The tribunal, where you have the dispute settlement committee.
Where is that?
Outline how complaints will be dealt with by, unless, on page 19.
Give me the page.
On page 19, Georgette, is it on page 19?
I think so, but Chair, I will just take the committee through it because it might be too small. It won't take me long.
Okay.
All right.
I just do it. Okay, so we have and as I said, this came from the Bureau. So just up there, there's a bit of preamble as to how the organization views the health and safety of its employees, staff members, as the case may be. So we have private contractors there as well, students and so on. And as Mrs. Robinson said, there's a thing there about the international protocols, how ILO views sexual harassment, the national policy for gender equality, so that there is our local context, and that there, the gender sector plan from the Vision 2030 and so on. The organization's zero tolerance commitment to sexual harassment, that is also there, and the wording can be tweaked, but we just put something there. Sexual harassment defined. So we try to make sure that it complied with the section in the legislation that stipulates what the policy is supposed to have. So different forms of sexual harassment there: physical, verbal, non-verbal, gestural, psychological, emotional, written, graphic, visual, audio, quid pro quo, and there's an explanation as to what each means: stalking, voyeurism, intimidation, bullying, retaliation, toxic environment, and so forth. Down here we have the responsibility of the various arms that would be responsible from time to time of ensuring that the policies upheld: management, employee, human resource department, welfare committee. And the intention is that
sorry, question, Miss Grant.
Yes, Chair.
Anti-sexual harassment dispute settlement committee.
Oh, that's where you are. Yes. Yes, Chair.
It would be helpful, just from my own understanding, the role and function of that particular committee. Not today.
Okay, all right. All right, not today, but
today.
Future.
Yes.
Okay, not a problem, Chair. And the internal mechanisms we have there, how the reporting procedure is, and if the reporting procedure is more, if it exceeds what is there, then sure. But as I said, just so that organizations, institutions have an idea as to how they can craft. Welfare officer or the welfare committee, if that is there. You recall that in a previous meeting, we had spoken about that particular focal point, yes, but yes, was raised by Norma Manley, but Mrs. Robinson had spoken about the gender focal points and how they work through the focal points. So that would also fall under the welfare officer. So you have somebody who's designated in sensitizing the organization and ensuring that the environment free of sexual harassment is maintained. There we have the Anti-Sexual Harassment Dispute Settlement Committee, and this is to give a nod to the internal mechanisms. So when you make your complaints and they are walked through, that there is a hearing, and then now if you're aggrieved, then according to the legislation, you proceed. Protection against retaliation as per the Act, the liability for harassment or sanctions, confidentiality, the legislation, and relevant legislation. So that is what the first schedule looks like. And then we have the other schedules. Mrs. Celia Brown, did you go through those?
The other one, I think it just deals with the oath.
Yes, the oath and the memorandum of agreement.
Yes, I did speak to the memorandum. We amended it. Okay. And it's just the second schedule, it's just a change of numbering. It's not anything that's serious. Chair, I see Senator Rodriguez, Miss Masado, and Miss Cunningham. Their hands are up again, Chair.
All right, let's take Senator Rodriguez. Senator?
Yes. Sorry about that. Just three little things. One, in the section which speaks the body language, nonverbal harassment. That section, I'm trying to scroll back up to it, where it says body language, where it says gestures, it says sexually suggestive gestures, and then it goes on to example. Could we have suggestive gestures / body language? Because there's a difference between body language and gestures. Is that possible?
That's in the policy?
No, ma'am, the section that we're reviewing now. You have
Yeah,
a section,
in the
forms
policy.
of
It's a
sexual
policy.
harassment.
It's a policy.
Okay.
Yes,
So
forms of sexual harassment, that's the
Yeah.
heading.
Right.
And
So go
the
again.
third section, nonverbal gestural harassment.
So
And then you have sexually suggestive gestures. I'm asking, could it be gestures / body language?
Yeah, I don't see a problem. Why?
Yeah.
Here.
Okay, and then the second one is, earlier we spoke about, Senator Gale probably remembers better than me. We spoke about the displaying of certain information from the policy within the institution. How do we ensure that we know it, since it's not mentioned in this section that we just went through in the schedule any at all? Do we need to put it in the schedule? How does it normally work? I'm new to this, so I stand to be guided. How do we put it somewhere in the schedule that has to also be displayed, or how will we, ensure that that happens?
So you want it to be inserted then that it should be displayed at a conspicuous point?
Yes.
Okay.
So does that mean displayed at a conspicuous point? This is the policy. When you display it, it means persons must have access to the content. Or is it you're displaying a statement?
Good question. It could be just a statement because it may get lost if the whole policy is there.
Yes. And this is where, again, I had raised the concern in terms of a policy of an organization. So the employees would have access to the policy. They would be aware of the policy and know that a policy exists, right? And in the institutions, the employees of that institutions and the students and the warders and the inmates would be aware that a policy exists and have access to the policy. The question is, we would have included clients. And as such, do we make it accessible to the clients, or do we make a statement around it?
I stand to be guided on it because I don't know what's the norm, but I think a statement on it is more effective than the entire policy.
Than making the entire policy available?
I think so. If requested, the policy should be made available.
Yes,
however, right, but if the purpose is to educate people on specific things, I think a statement around it is more effective. But I stand to be guided.
I got a bit distracted there, Chair. Yeah. So is it then that we'll include it in the policy in terms of how it is to be brought to the attention of the clients, the
parties involved?
Okay, so you want us to stipulate that in the policy, or you want just
you can make a statement, that the policy should be available.
Should be available, okay.
Should be available. Right?
Okay.
Because there are so many penalties for things that people may not know. You want to make sure that we find a way, because that's part of the problem with some of the laws in Jamaica. People don't know. And this one is about
you want to ensure in all instances that people are aware of their scope of permissiveness.
Exactly. Because this is important. We're breaking something that is becoming cultural in Jamaica. So we're going to go that little extra mile.
Okay, so we will put it in, Chair. That is not a problem. towards the end, maybe?
Towards the end?
Or should we put it in the section that deals with the responsibility? Sorry, Chair.
Where?
I mean, as to make
when you said the end, what you meant? Define the end in your thoughts.
Towards the end of the policy.
Of the policy.
Yes.
You see, it could be at the beginning of the policy where you make the statement, so it stands out.
All right. Okay, sure. All right, that's not a problem.
Not after you go through it, then you see that it is so prescribed. Make the statement up front.
Good idea. And then my third thing is.
So then, sorry, Senator Rodriguez. Once you make the statement up front, then it will trigger persons to the need to go through the policy because of its importance.
Yes, Chair. Okay, so we'll put it up at the front then.
Yes, Senator, continue.
Of course, my favorite issue. Ms. Grant, feel free to roll your eyes right now. We had stated in the last meeting, if I remember, or the meeting before that we would state something specifically pointing to the fact that in the first review, the matter of boards should be addressed. I told you I was bringing up my favorite one, Ms. Grant.
That's for the report.
That's for the report, Senator Rodriguez.
That's for the report.
Oh, so that's where we agreed. I just don't want anybody to forget.
No, we would not forget. But that's for the report.
All right. Thank you. So Ms. Grant, you can't roll your eye again then.
She may roll her eyes in agreement. I think we had Ms. Cunningham and who else?
Carissa's hand is up, Chair. Ms. Masado's.
Ms. Masado.
My hand was up in error. I apologize.
Okay.
Okay.
Okay, mine was just a minor matter. In 3 places in the schedule, I see where we have Sexual Harassment Prevention and Protection Act, but based on the title of the act, it's in the reverse, Protection and Prevention. So I just wanted to point that out. So it's under the heading Definition of Sexual Harassment in that paragraph.
Yeah, yes.
And it's also on page 19 at the bottom under the heading Protection Against Retaliation.
Page 17.
And on page 20, the last paragraph under reference to relevant legislation.
Tell me the pages again, please, Carissa.
Sure.
Page 16.
Yeah.
17.
17.
19 and 20.
19 and 20.
Okay, thank you.
It's 2 places on page 20, Chair.
Oh, okay.
Yeah. It's on page 19, you said?
Yeah, I saw it on page 19 also.
Okay, it's not on my page 19.
Protection against retaliation.
Yeah. This anti-sexual, Georgia, this anti-sexual harassment dispute settlement committee, what's that? Is it that we were supposed to substitute that to the sexual harassment tribunal?
No,
on page 19?
It's a part of the internal mechanism.
Okay, okay, thanks, thank you.
So this is a committee now that deals with the question of education and, you know,
okay.
I'm just assuming.
Yes, it's internal.
Yes, it's internal.
Yeah.
As well as hearing whatever complaints.
Okay. Okay, Chair, that ends my presentation to the committee.
So I will make those changes, Mrs. Seeley Brown, and I'll send it back to you.
Thank you so much.
So we would have completed. Minister, are you on? We would like to hand over to you at this stage.
Thank you. Thank you. I have to go on. Call it back. Yes. Thank you so much, Senator Gale. Thank you. So we have colleague members and technical team. I want to thank Senator Gale, and certainly this underscores how important it is for partnership and for us to ensure that there is gender equality. So Senator Gale, I really want to thank you so much. You will notice that the team has been predominantly women.
I noticed that from the start.
But you have had your equal exposure. And so that has balanced the scale. I really want to thank all the members. You have all been fantastic. You have all applied yourselves so well, and you have actually challenged the status quo in making your input in this legislation. I want to thank the technical team. You have really worked very hard to make it happen. I mean, I just don't know what to say. The Solicitor General, the entire team, you have been tremendous. So today marks a triumph for the people of Jamaica. You should applaud yourselves, and we should applaud the viewing public that have been out there watching us.
Yes, yes.
Watching us. You know, it has been tremendous. And for the important role the public broadcasting of Jamaica has played in giving exposure, not just here in Jamaica. We get calls from all over the world. Persons have been watching us, watching the deliberations. Every single individual on this committee and on the technical team has a fan out there somewhere in the world. There have been just great comments about each of you.
I've had feedbacks from Africa.
Yes, yes, it's really been tremendous. I know while we speak, there is one particular lady in Canada who is watching. And at her office, they ask her, why aren't you working? Why are you watching? She says, I'm working and watching, but I have to keep in touch with my country and what's going on. And she knows who she is. I won't call her name, but just to say, thank you for giving us the support. So through the steady guidance by Mrs. Seeley Brown and the other members of the technical team and the Solicitor General, we were able to approve the amendments to this seminal piece of legislation. I can't leave out Georgette. Ms. Grant, thank you so much. I know that after we close off here, I'll be calling you about the Domestic Violence Act and the amendments to it. But you're equal to the task.
Good work just means more work here, Georgette.
That's correct. That's correct. And what we have managed to achieve can only be credited to the diligence and perseverance of all. We can agree that these amendments have significantly improved the bill. And it is my belief that the people of Jamaica will be better for these amendments. After the finalization of the amendments, we will lay before the Parliament the report from this committee together with the amendments to the legislation. And that again is an achievement. We're not just going to lay the report, but the technical team, they have worked hard enough to have the amendments ready. So we will lay the report along with the amendments. And that is tremendous. I make my sectorial presentation on the 8th of June. And I am telling you, I'm just beaming with pride because I will be able to lay the report and the amendments on that date. And that is really, really tremendous. You can applaud yourselves.
No. Now we know why the whip was cracked.
You can applaud yourselves. And the process will mean that I will attempt to have the debate begin. If I can't begin the debate on the 8th, we will begin the debate in a matter of days, either the Wednesday or the following week. And we will take the legislation through all its stages and pass it, and then it will go on to the Senate. Goes to the Senate, it goes through the same process. And I'm saying all of this also to educate the public. Let them know, sometimes they think we're not working, but there's a process. And so it goes to the Senate, it goes through the same process. And if they make further amendments, it will come back to the House. We are also attempting to have the regulations ready at the same time, right, Ms. Grant? We're making every effort to do so.
That would be earth-shattering.
Yes. And then once everything is in place and it's passed and signed off on, it will go to the Governor General. Well, we have done a lot of work in record time. As chair of the committee, my expressions of gratitude to all of you who have aided in the driving of this process. And my praise can never be enough. Again, I want to commend the Public Broadcasting Corporation who continue to carry our work live, not only on cable television, but also online. To the Hansard writers, thank you. And to the dutiful clerk, Miss McCarthy.
Yes, yes.
Oh, you need to applaud her.
Yes.
Thank you, thank you, thank you. I'm really very happy about this. And I can say that we have fine-tuned the deliberations coming from recommendations that have been made both by public and private sector, as well as civil society. And I just want to thank everyone. We're going to be proud of this legislation. I want to really thank the Bureau as well. Mrs. Robinson, I want to thank you and your team. We're all applauding you for your work. And once this legislation is passed, then the real work begins. And we're going to have to ensure that we have a very effective public education program, because this is really going to impact on how we even our cultural norms and posturing at times, you know, because there are those who don't really mean to be rude or to be offensive, but their actions at times can be so interpreted. The nuances that exist in our society and our attitude in our home culture, we love to hug, we love to embrace, you know, we love to talk and touch people. We love to do a lot of things that we're now going to have to be sensitive and conscious about. And it's really going to take a whole behavioral change. But we are all equal to the task. And I know Jamaicans want to ensure that we improve our behavior and that we show more respect to each other, that we show more respect to our women and to our brothers and our sisters. And this piece of legislation is going to assist in changing behavior for the better. So I just want to thank you all. God bless you all. And I'll see you all in Parliament. Thank you. See you on the 8th. Chairman, our deputy chair, our co-chair, Senator Gale.
Yes, Chair.
You have been fantastic.
Thank you very much.
What I'd do without you.
I tell you, this would have been one of the most enjoyable committees that I've gone through in terms of the deliberation and the
Yes.
hard work and the feedback. It has been excessively, enjoyable for me.
Yes.
And it was a learning process.
Yes. Everyone has been so engaging,
Yes.
And Senator Campbell Rodriguez, as a new kid on the block, are one of those in Parliament from the team of new senators, women senators as well. And, just all the new members members of Parliament. You have all been tremendous, both in the Senate, from the Senate, and from the House. And of course, the old hands, not meaning old in terms of age, but Senator Scott Motley, and we have been just so united in our effort in this regard. Absolutely every single member of this committee and every single member of the technical team and every single member of the staff of Parliament, you have made your impact. You have been tremendous. I see MP Sibley's, he has his hand up. He wants to make closing remarks. Okay, MP Sibley's, please go ahead.
Thank you, Chair. Chair, I just want to thank you for having me on this committee. It is indeed an enjoyable journey for me. And this bill means a lot, having experienced complaints made by persons and from the side of the employer, as well as to how to manage complaints. And I'm glad that Jamaica is right here in history to get this piece of legislation out. I agree with you, Chair. It is certainly new and a lot of cultural changes that has to be made. And the educational drive will be one that has to be properly managed. But as a country, we can.
Yes.
I really believe in my people.
Turn your camera on.
I really believe in my people. Let me see if I can get this camera on. Because I'm using the hand device.
Yes.
So I really am very happy that we are getting to the place where we want to. And that our women folk and our men folk can understand how it is to communicate without letting or allowing each other to feel abused in any way, shape, or form. So, Chair, I want to really thank you because I wanted to be on this committee, this Joint Select Committee. And I thank you for considering my request, and it has been a beautiful journey. Thanks, Chair.
Thank you so much, MP Sibley's. I'm going to ask everyone to just, where you can, to put your cameras on as we say bye to our audience, our viewing audience. If you could put your cameras on where you can. Mrs. Robinson and the team, could you just all put your cameras on? MP Sibley's.
Fix that camera.
Mrs. Robinson, Ms. Mack, let them see the hardworking committee secretary. Senator Scott Motley is still here?
Oh no, she apologized. She had to leave.
Okay.
And so did Senator Fraser Binns.
Okay, fine. So I want to use the opportunity to, on your behalf, to also express condolences to Senator Kamina Johnson-Smith, member of our committee, who lost her father, Ambassador Anthony Johnson, and whose memorial service was held yesterday. She was not able to join us this morning, but we just want to recognize her work and her input in this process as well. All that's left for me to say is keep safe, wear your mask, sanitize, keep your distance, and keep safe.
Get your vaccine.
And take your vaccine, that's right. Take your vaccine. All the best.
Thank you, Minister. You too.
Thank you, Minister.
So much.
All
And
right,
we can
team.
say bye to all those folks watching us
Bye.
overseas.
Bye.
Take care, all.
Take
Have a
care.
nice weekend.
Bye all. Keep safe. Keep safe.
Thanks, everyone.
Thank you.